two GR number is the issued by the JMFC. So we have a little confusion. So we have to authentic the which one is the correct GR. So I may allow to withdraw and file a press.
Okay. Learned counsel for
R Nabam.
R Nabam, learned counsel for the petitioner, seeks to withdraw this petition as some errors are stated to have crept in, which need to be corrected. And he seeks liberty to file a fresh full stop. The prayer is allowed. The petition is disposed of on withdrawal with liberty to file a fresh.
Lordship, the original mutual settlement copy dated 15/5/26 May.
The original settlement copy dated
28/25.
20.
20/08/2025.
Okay. May be returned.
May allow to.
Next to the petition.
My lord, 11/5/26.
Which one?
There's mutual settlement.
Not 20. Not 20.
No, not 20.
Oh, no.
11/5/2026.
That is the final. No? 11/5. The agreement dated 11. Original agreement 11/5/2026. Annexed to the petition may be allowed to be taken back.
My lord.
Done.
My lord, I beg to mention item number 28, my lord.
28.
Yes, my lord. For withdrawal, my lord.
28.
Yesterday, this matter was taken up, my lord. Since
you want to withdraw
yes,
this matter?
yes, to
Okay.
file press, my lord. Since IO has sought for the sufficient days, my lord. So on appropriate time, we'll file press, my lord.
Learned counsel for the petitioner submits that he has instructions to seek withdrawal of this petition. Full stop. The prayer is allowed. The petition, criminal petition is disposed of upon withdrawal.
With liberty, my lord, to file press, my lord.
Full stop. Disposed of. The learned counsel also seeks liberty to file afresh after any subsequent development.
My lord, my lord.
After any subsequent developments, the prayer is allowed.
Obliged.
Yes, please.
My lord, I beg to mention item number 7. Leading counsel is out of his session due to his personal difficulties.
Which one? Item 7.
7, yes.
You for the petition.
Yes,
appellate.
the respondents.
Respond.
For
Inform the other side.
Yes,
Inform
I
the
have informed the other side. Matter may be listed after 3 weeks.
Learned counsel for the respondent, all the respondents.
Yes.
All the respondents, all the 5 respondents. Pray for adjourning the matter today, as the learned leading counsel is stated to be outstation. He submits that the consent of the other side,
Yes.
the appellant side has also been taken. Prayer is allowed. List after 2 weeks.
Yes. Must
It
apply.
need to be fixed by registry.
Lordship, I beg to mention item number 6.
Item 6.
Yes, matter may be taken up after 3 weeks, Lordship.
You are for the petitioner.
Yes, I'm for the petitioner. I have informed the other party person.
Learned counsel, good name.
Yes, Iram.
Learned
S. Iram.
S. Iram. Learned counsel for the petitioner. Prays for listing the matter after 2 weeks.
Yes, Lordship.
And further submits that he has taken the consent of the other side. So prayer is allowed. Any interim order?
No, Lordship.
No. List the matter after 2 weeks on a date to be fixed by registry.
I beg to mention item number 7.
7.
The leading counsel went back to his hometown to present the hearing of.
No, the previous number was how?
7.
You just mentioned 7, right? Already mentioned, I think. You just. The number you mentioned was?
6, Lordship. The 7 was mentioned by the other.
Okay.
My lordship, I beg to mention one unlisted matter.
Bail.
No.
Monday? Little be on Monday.
For tomorrow, your lordship.
Tomorrow.
One unlisted matter.
We have a packed actually list. If it's not very urgent, Monday will be best. I think.
Your lordship, it's an ordinary matter, your lordship.
Or on Friday. You take it on Friday.
Friday.
You want it tomorrow?
Yes.
Insisting on tomorrow. Okay, fix it.
Obliged.
May I, your lordship? I beg to mention item number 10 and 34. The leading counsel is currently out of session.
10 and 34.
Yes, Lordship.
You are for the petitioner?
Petitioner.
Full stop.
Lordship, in item number 10, I'm for respondent number 1 to 4.
All the respondents. Yes. Your good name, please?
Titolo, appearing on behalf of Aringo.
Learned counsel for the petitioner, item 10. No? 6 an adjournment. He is out of station.
Yes, Aringo is out of station.
As the learned leading counsel, R. Ingo is out station. Full stop. The learned counsel for all the four respondents appears and has no objection. Full stop. Please the matter after 2 weeks.
3 weeks, sir.
After 3 weeks.
Lordship,
Any,
short date may be given. Otherwise, this matter is the.
let it be after 2 weeks.
Okay, okay.
After 2 weeks. You want me to fix a date?
No, Lordship.
After 2 weeks on a date to be fixed by registry, any interim order?
No.
We'll check it in case.
Leave.
Another one, right? 10 and
34.
34 may not. So there are three matters together, my lord.
Oh.
33, 34, 35.
I see. Mhm.
See the array thing, my lord, where I am appearing for the NIPCO. My
Okay,
friend Mr. Pathak is appearing for the other private respondent.
okay,
And it stated there is appearing in that matter.
okay,
And 34, they are mentioning, my lord. In that case also, I am appearing for the NIPCO.
okay.
And my lord, 35 is another CRP, my lord. That is also connected to the
Yeah.
appeal 7.
You are appealing for NEPCO in all the 3 cases. So, should we adjourn it?
My Lord, I have some reservations, my lord. Though these matters are tagged, the
Mm.
CRP in item number 34, this is a matter where the question of whether the court can take up the reference or not,
Mhm.
as made by the deputy commissioner, is in.
That is a sale.
Yes, sir.
That is,
In our cases, my lord, the reference is already successfully made. The reference court has already given a verdict.
Mhm,
The matter is therefore now in appeal before this court.
mhm.
And the question is almost
that is
1.5 years have gone by.
Yes,
There's
yes.
no deposit or
So, what, yeah.
May I just point out one other thing, sir? In fact, my lord, why this all the matters are taken together, my lord? So for 35 is concerned, my lord, this is numbers to be what is related to the execution matter.
This is the execution. 34 is
30.
that issue, and the appeal is this one. Well, so,
The appeal is basically, my lord, we are saying, my lord, the entire case is that, my lord, whether the 2013 Act will apply.
or the other.
Earlier Act will apply.
Mhm.
That is the question. In their case also, my lord,
Mm.
the same thing. Because, my lord, the reference was, my lord, rejected. They say that the reference cannot be accepted
Mm.
because of delay and other problems. Now, the entire question will be that has to be decided whether 2013 Act or
Okay.
18 Act.
We have some important case laws for guidance on that point,
Yes.
right? Which about the application of this. So on you are appearing in all the 3,
Only
30.
34.
only 34 for the petitioner.
Petitioner.
On what ground you're seeking adjournment?
Council is out of session.
And who's the council?
Aringo.
Okay.
Second.
Reckoningo is out station. So what to be done?
But appeal actually has to be decided first because that issue will
Once the
firstly
appeal is
concern.
decided, other issues can-
Is it necessary to be tagged? Like,
It will be better, my lord, to
Better.
take, otherwise, my lord, what happened, is decided separately, other problems will be arising.
Yes, if it goes to another bench and another decision is given, then
Because, my lord,
that
the
is
basic
one
question
difficulty,
is,
of course.
we are saying that LA Act, my lord, is Land Acquisition Act.
and yes, another option is to list them on the same date, but separately. That is also an option, but
That's it.
we'll not touch this today. Let it remain tagged. That aspect will not, that aspect I'll not touch today. Let it remain tagged. If later as you said, the appeal progresses, and there's some issue, then you get it listed on the same day, but without tagging.
It is decided, their case will be automatically decided.
Okay. So anyway, we adjourn.
A lot, there was an order last year in the month of May that this is to be taken up on a back-to-back basis on hearing. Because there's no deposit and if at all payment is to be made, my lord, a huge interest is
Then you
pending.
work out a date.
Therefore,
we'll fix
every
a date.
day lordships have
Yeah.
fixed back-to-back dates in this matter.
We'll fix a date. In fact,
14th of September.
we can.
My lord, the learned AG's convenience also has to be seen
My lord,
because his presence should be required.
Have-
We will.
Have,
He has informed.
yes,
Madam.
please, yes.
He need not worry about that.
You also, yeah. You talk to your senior also, right? And talk to senior colleagues. Please walk out a date. We'll give it and then that day you start the hearing.
As soon as we get the, then.
No problem. Take your time. I'll proceed with the list. No,
Highly obliged.
we need not make mass an order now. Any other mention?
Item number 1.
May I please, my lord? My lord, matter may be pass over for a while, my lord. Because the council is appearing for BC.
Is
but
another,
due to some technical problem, he was unable to appear, my lord. After who, my lord?
after some time.
Yes, my lord.
This is a charge sheeted case.
Yes, my lord. Already submitted. Yes, ma'am.
Item number 3.
Mayor Lordship. Lordship, this is a joint petition for passing of an FIR, Lordship. Lordship, the FIR is in page 20, Lordship. May I read it? The FIR is page 20.
All right.
To the officer in charge, Women Police Station, Itanagar, Arunachal Pradesh. Subject, false information against Mr. So-and-so. Madam, I, Miss So-and-so, daughter of So-and-so, resident of Julang near Don Bosco, Itanagar, Arunachal Pradesh, respectively submit that this false information report against Mr. So-and-so, resident of So-and-so, near So-and-so. Lordship, is said that in March 2022, it's talking about an incident, Lordship, in the year 2022. While engaging in the business of selling local machetes, that is Dow, I came into contact with Mr. So-and-so through our mutual friends, Miss So-and-so, so-and-so, so at XYZ bar. That in April 2022. So Lordship, she said, in April 2022, I went to his residence along with machete, that is local Dow. Upon arrival, I was surprised to find that his parents were not present. When questioned, he replied that they had gone out and suggested that we wait. He then invited me to look around his house and subsequently.
The FIR was dated, FIR is dated, it was lodged in December 2025.
25 in,
But she mentions about the incident in March 2022.
that is April, Lordship.
April.
She said in March 2022,
Okay.
they came in touch
Yes.
with each other in the
The incident is
April
separate.
2022.
Okay, okay. So carry on.
So this is Lordship. That in April 2000, I went to station along with local machete local. Upon arrival, I'm surprised to find that his parents were not present. When questioned, he replied me that they had gone out and suggested that we wait. He then invited me to look around his house and subsequently took me to his room. There he closed the door and without my consent began to touch my private part. He then forcefully laid me down on the floor and committed rape upon me. Despite my resistance, he overpowered me due to his physical strength. That madam, after the incident, I confronted him angrily and questioned his action, slapped him once and fled from his house. Lordship, she said that the delay in lodging the FIR report was due to circumstances beyond my control. At the time of incident in the April 2020, I was a minor. So this is owing to severe emotional trauma, shock, fear, and social stigma and intimidation by the accused. I was prevented from approaching the police immediately. Now, only upon attending courage and receive support and well-wisher, now I'm able to come forward and seek justice. That madam, so-and-so has without provocation circulated false, vulgar, obscene, and fabricated allegations describing me as a woman of loose moral with deliberation intention to injure my reputation and dignity. That is, she has said malicious statement to witness. The accused falsely informed Mr. So-and-so that I had hooked up with him casually and instead that he's wholly untrue and intent solely to defame, degrade, and socially humiliate me. So the second page, Lordship, that he approached my fiancée so-and-so and made the following false, derogatory, and defamatory statement that I slept around with many men, that I am not of character good, that I go to bar and what his time pass girl, that then I can destroy the family and that my fiancée should leave me. This statement were made maliciously with the intent to malign my character, disrupt my relationship, and destroy my social reputation. That I possess an I possess an audio recording of the conversation between the accused and my fiancée, in which the aforementioned defamatory, insulting, and intimidating statement are clearly audible. The accused has persistently been spreading filthy, baseless, and scandalous allegations against me within the community, despite knowing that such statements are entirely false, thereby causing me severe mental harassment and grave injury to my reputation, dignity, and emotional well-being. Therefore, I request you to kindly register the complaint under relevant provision of law and take necessary action against Mr. So-and-so for the offense committed against me. So at that point, Lordship, this yours faithfully, this is the complainant. And Lordship, during this, since I was apprehending being arrested by the,
You are on bail,
no, Lordship, I have never been arrested. Lordship,
never been arrested.
no.
Then they made this agreement.
Lordship,
So we'll call for the records,
yeah.
but I'm slightly, I'm not very sure about the stay because it's a POCSO case.
Yes, my lord.
And POCSO case have their statutory timelines.
Yes, my lord. Yes, my lord. My lord, so far as the stay is concerned, even this is not a case for the stay, my lord. I would like to highlight
Statutory
one thing.
timelines
Yes,
they have.
highlight one very interesting.
That's why I asked this question. You apply for bail, you seek file a separate application for bail.
My lord, on that aspect, my lord, allow me to make a submission. Let
Yeah,
my
sure.
brother complete. I
Of
will
course.
show you, my lord.
Of course.
Yes.
Of course.
Lordship, like I was granted interim bail by the trial court also. But Lordship, there a new development came up. The complainant said that one of my brother and advocate, they had approached her to give a false statement against them, before the court under section 138, 183 for the magistrate. So Lordship, taking into that consideration that since pre-arrest bail was granted to me, I have misused that pre-arrest bail. So the trial court the session court has rejected my bail application. And Lordship, accordingly, I had approached before this honorable court also. But honorable court also, after granting the interim,
It was cancelled.
it was cancelled on the same ground, saying that since like I have approached, misused my liberty. On that ground only, Lordship, I have my pre-arrest bail was rejected by the honorable court. BS that my Lordship, since I'm not going into the merit of the case, Lordship, here we have come into a mutual agreement, and that's an affidavit by the complainant also, that's saying since Lordship prolonging the case.
POCSO cases cannot be settled actually.
Yes, Lordship. But
That
Lordship,
is, you are of course aware of that as a learned counsel. You are aware of that. POCSO cases, it's very, they fall, per se, they fall outside the zone actually, outside that zone created by these decisions, Narinder Singh and Lakshmi and all that. Anyway, but of course, the common point is that we'll have to get the scan record. You would seek a stay, and I will hear the prosecutor. Then I'll come back to you.
yes, sir.
Now, my lord, so far as the on merit regarding, my lord, the whether the POCSO can be quashed or not, my lord, it is well said. Now, I will not on that, my lord. That will be, I will argue on the, my lord.
Decide that later.
Yeah, later, my lord. Now, my lord, may kindly come to page number 28, my lord.
28.
Yes, my lord. What, my lord, the interesting issue before this honorable court, no doubt, my lord, this aspect has already been decided by the Punjab High Court, wherein, my lord, the lesser prayer has not been entertained by the court and it's attained its finality. Then the petitioner, without getting that lesser, my lord, remedy, they cannot invoke the higher remedy. That is for quashing. Why I am submitting this, my lord? Here, my lord, anticipatory bail was page number 28, my lord, Annexure 3.
He's what is the name of the petitioner? This first one.
Petitioner name is, my lord,
The petitioner number 1, Lordship.
Yeah.
It's the complainant, Lordship.
Dolang Yanya.
No, how many petitioners are there?
There are, my lord,
4 of them.
total 4.
4 of them. The girl is petitioner number 1.
1.
Lordship.
Yes.
And the main accused is 2.
2, yes.
And who are the other 3? Other 2?
Lordship, the other 2 is the elder brother of the accused. During the course of
Elder brother and
the other is a Lordship.
Advocate.
He's an advocate. There was an allegation that these 2 persons has approached the.
Oh, sure.
For settling the matter, my lord.
Okay. I'm on page 28.
Yes, my lord, in 28. My lord, Annexure 3, my lord. Annexure 3. That is Annexure 3. Bail application, my lord. This is the AB, my lord, rejected by this honorable court, my lord.
Bengo Chabu.
Bengia Chabo, my lord.
Chabu, who's the accused?
Yes, accused, my lord.
Acha. So,
He's the main accused, my lord. There is an allegation for the sexual assault penetration.
They have not reached to the root of the investigation, Lordship. So, Lordship, mechanically, they have just charge sheeted, Lordship.
we have to see that.
Lordship. Prima facie, Lordship,
We have
this
to see that.
is their defective.
Madam Jin,
Yes, Your Lordship. Your Lordship, if Your Lordship see the charge sheet filed by the IO, Your Lordship, the relevant portion I would like to rely upon is at page number 34. Since the charge sheet is a very long one, Your Lordship, I'll just rely on the relevant portions. Your Lordship. If I may read the last portion, Your Lordship.
of 34.
34 of 34. Upon reviewing the FIR submitted, it was found that most of the possible sections applicable for the said FIR were non-cognizable in nature except for forgery. Hence, a preliminary inquiry was initiated to verify the facts regarding the same. The matter was taken by so-and-so. After the approval of so-and-so for preliminary inquiry, the matter was taken up by itself. So, as per the FIR, the village of Janching had claimed that they have document dated 23rd October 1984, on which a boundary dispute settlement was done between the villagers of Chalan and Janching. Further, according to which a boundary stone was laid in the area lying in the straight of the line of the stone was boundary. Once Sri Biri Kunjunju of so-and-so village has submitted a boundary dispute agreement, Annexure 1, along with an application to the ADC office Nafra White so-and-so, dated so-and-so, on which Biru Kunjunju has claimed that area claimed by villagers of Chalan village actually belongs to Janching and should not be entertained by the office of the ADC. Nafra, as an agreement has already been done on 23rd November 1984. Your Lordship will record the year of the document, Your Lord. Regarding the same. A notice under so-and-so was served to the office of ADC to procure the application submitted by Sri Biru Kunjunju, what's white memo number so-and-so, dated so-and-so, along with annexure. Upon verifying the application submitted by Sri Biru Kunjunju, white so-and-so, dated so-and-so, it was found that the document submitted at the office of the NAFRA had some irregularities, as the document itself seems to be typed in a computer, which could not be possible for the period of 1984. Accordingly, a notice under section 35(3) was served to so-and-so with a direction to produce the said documents of boundary dispute settlement between the villagers. Following which, Biri Kunjunju was questioned for the same, to which Biri Kunjunju stated that the document has been made in recent year, when the original document went missing. Your Lordship will see that. And they needed a supporting document after a land dispute erupted between the two villages in the year 2023. However, after some time, he found the original document dispute settlement document. Photocopy of the same was then submitted to me by so-and-so, which he claimed to be the original document. During the inspection of the original boundary dispute agreement so-and-so, it was found that the said document was made using typewriter machine and in the original document signature of one late so-and-so, while fingerprint was used by LT so-and-so on new boundary dispute settlement documents. A photocopy of the original documents was then taken for record. Upon further questioning, so-and-so said that he had the affidavit signed by two of the alleged witnesses present during the original settlement of 1984. The two alleged witnesses were so-and-so and late Sangja Aka. The photocopies of the said documents were then submitted by Sri Biru Kunjunju itself. However, no such document was produced for one of the alleged witnesses, that is Karu Aka, present during the said settlement of November 23rd, 1984. Accordingly, as per the document of the village of Science, claimed that the boundary of the village lies as per the zone. Now, Your Lordship, as per the finding of the preliminary inquiry, it was derived that a boundary settlement dispute was allegedly mediated between the villagers of Jachang and Chalang on 23rd November 1984 by three persons: Sasu So, late Karu Aku, so-and-so, and late Sangju Aku. Now, Your Lordship, this investigation revealed how the signature was made, Your Lord. During the settlement, a document was formed demarcating the boundary between the villages. However, this document went missing for a brief period of time. And when a document dispute case developed between the villages in the year 2023, they had to develop a supporting document. Hence, they made the new boundary dispute settlement document and submitted it to the office of the ADC. White memo number so-and-so, dated so-and-so. Upon verifying the new boundary dispute agreement, it was found that the original document had only one page. However, the new made document dispute agreement were 3 pages with later 2 pages containing the name of the villagers from Janchang and Chalang as witness. Therefore, as facts obtained during the preliminary inquiry, it was evident that this matter attract 340, making the case cognizable in nature. Hence, so was FIR was registered White NAFRA PS case number 1 of 26 under 342 BNSS and was taken by self for investigation. Also, upon examination of one of the alleged accused, Sri Biri Kunjuju, he stated that he had submitted the application White to the office of ADC Napra White Memo so on 13/3/2022 to support their village claim on the land dispute. Furthermore, when he was asked about the original copy of the newly made boundary dispute agreement submitted as above, he stated that he has misplaced the original copy of the said document. Hence, he won't be able to produce it for investigation purpose. On the question Sri Biru Kinjunju about who was involved in the creation of the same documents, he stated that he had created the document by self after getting the signature of the mentioned witnesses, and he refrained from mentioning any names involved in the case. Hence, Biri Kanjuju was served a notice under 94 BNSS on 19/3/2026 to produce the original document of the certain documents involved in the case for investigation purpose. Since the act of the forgery was being applicable to one of the accused, Sri Biri Kanjuju, as of now, a bail bond of so-and-so was impossible. The next paragraph, Your Lordship. On 19/3/2026, all the other accused, namely Sri Kumar Kunjunju, Sanjay Kunjunju, Chonda so-and-so, Riji Kunjunju, Maili Kunjunju, Jitung Kunjunju, Mango Kunjunju, Niko Kunjunju, Sunil Kunjunju, and Gumswai Kunjunju were issued a notice under 35(3) to appear at NAFRA PS for the purpose of the statement recording. Further, it also came to our knowledge that one of the alleged accused, Sri Chongwei Kunjunju, has passed away 1 month back, and this was verified from one Sri Rijin Kunjunju. During the examination of the above mentioned person, all of them stated that their village, so-and-so, Janching and neighbor village Chalan has been coexisting peacefully for a very long time. However, after 2018, since the complaint in this case, Sri Sangju Jaboju has been president of this village welfare society, namely Chalan Welfare Society, many false claims have been made by him regarding land boundary between our village. This has led to many confrontation and unwarranted tension between the villagers. Sri Sango Kinjiju is currently serving in the force of so-and-so with its headquarters at Namsangmuk, Tirap. Since he is a government employee, he should not cause disturbance to the peace and tranquility between the villages. Even after many advice by him about the same, he did not listen, due to which they decided to take action against him by reporting his commandant located at Namsangmuk, Tirap, about his involvement in destroying the peace between the villages, for which they signed a complaint against Sangju Jaboju and submitted to Commandant so-and-so. On 10th February 2026, they went to Chimpu Itanagar after they were summoned by the officials IRBN to give statement for their complaint. During the journey, they clicked a photo at Seppa viewpoint where one of the alleged Sri Gumso Kunjunju had worn the Gambura coat for photo purposes only, and it was not worn at Chimpu during the recording of the statement. Or further examination of one of the accused, Sri Gumsai Kunjunju, he stated that he had representing his village as Gambura. Your Lordship will find he has admitted, Your Lordship, for some time after his father has been ill and was able to perform his duty. He also stated that he had signed the statement given at Chimpu as Gambura. That is on behalf of his father, Your Lordship.
Okay, so I think
there is a, Your Lordship will also see the other signature being taken, Your Lordship. It was not when one of the person was on his deathbed, a thumb impression in an affidavit was taken. That was not a signed copy of the document that they have produced before the ADC, Your Lordship.
so call for the record, I think.
Well, yes,
This-
Your Lordship.
just
Because,
call for the record. Call for the record. Are you on bail?
Yes.
No problem. Heard, learned counsel for the petitioner and Jeannie, learned additional PP for the state. The petitioner invoking section 528 BNSS. Only one petitioner, no, three petitioners.
Three of them.
The three petitioners herein invoking section 528 BNSS are seeking quashing of criminal proceedings being GR case number 14 of 2026, arising out of NAFRA PS case number 1 of 2026. Full stop. Under so-and-so section. Full stop. The case was registered based on an FIR dated 17/2/2026 with certain allegations. After completion of investigation, a charge sheet was filed against the three petitioners under section 342. It's there in page 100. I've marked. Okay. Full stop. Subsequently, by order dated 23/6/2026, the court of the learned CJM West Kameng District, Bomdila, has taken cognizance and summoned the accused persons. The learned counsel submits that the petitioners are presently on bail. Next paragraph. The learned additional PP has taken the court through the narration in the charge sheet, which was filed after completion of investigation. At this stage, next paragraph, at this stage, call for the scan TCR of GR number so and so, comprising the case diary, charge sheet, and other relevant documents. Please the matter on.
May I please, Lordship? Lordship, I have a interim prayer.
Interim prayer, I'm not passing any order now, since you are on bail, because this has to be looked in. Let the records come, and then we can keep it open for subsequent.
Before the next date then, Lordship.
The learned counsel prays for stay of the proceedings by way of an interim
Lordship.
order, full stop. However, the question of interim order staying further criminal proceedings is kept open for subsequent date. It's kept open.
Your Lordship may list this matter after 2 weeks.
Yeah, list after
2 weeks. Your Lordship.
after 2 weeks on a date to be fixed by registrars.
Item number 5.
Your Lordship, a small request, Your Lordship. In item number 4, a notice may also be issued to the respondent number 2, Your Lordship.
Oh, yes. Yeah. Steps of notice shall also be taken. Please use the steps of notice shall also be taken upon respondent number 2, who is the informant of the case. Steps by speed post.
May I please, Lordship?
Yes.
Lordship, this is a joint petition filed by the complainant and the accused person, Lordship.
Jointly.
Lordship. Lordship, FIR was lodged by wife. The wife, Lordship. It's on page number 13, Lordship.
Karbi Riba Lohi is the wife. Karbi Riba is the wife. Nyato Lohi is husband.
Lordship.
Where is the agreement?
Lordship, Lordship, amicably they have settled 2 times, Lordship. Firstly, they have settled in 2022, Lordship. Locally, they have settled. And then after, to bring into record, they have settled.
Formally, they have settled. Where is the agreement?
Agreement, Lordship, page number 47, Lordship. Annexure 5.
Annexure 5.
Now they are living together peacefully, Lordship, with their children, Lordship.
This we can call for the record and stay the process.
Yes, ma'am.
Heard Mr.
Ketabang, Lordship.
And Mr. Ate learned additional people. The petitioners herein, who are husband, wife, as well as the informant and accused respectively, who are wife and husband, as well as informant and accused respectively, have jointly invoked the inherent jurisdiction under section 528 BNSS to seek quashing of GR case number 497 of 2021. Arising out of Itanagar Women PS case number 74 of 21 under 498A 506 IPC. The said case was registered based on an FIR lodged by petitioner number 1/wife on 11/10/2021 with certain allegations. It is stated and submitted that subsequently the parties entered into an agreement on 12/6/2026 with the help of friends, relatives, and well-wishers. Whereby they are stated to have amicably settled their dispute and amicably settled their dispute. Full stop. It is revealed from the agreement that the parties also have 3 children. The youngest one aged about 7 years. In the backdrop of the said agreement, the instant quashing petition has been filed. The case is stated to be pending before the learned. Where is it pending now?
JMHC Lordship, JMHC Naharlagan.
Magistrate first class, Nahalagan, district Papum Parang.
Where?
Malad in the para post title.
Para?
Malad in first page only, Malad.
First page.
Yes, Malad. Proceeding GR, Malad.
Page?
Page number 1 itself, Malad.
1 itself.
After.
Oh, yes.
One.
Sorry, I missed. The
There-
case is stated to be presently pending before the court of the learned JMFC, Naharlagun, Papumpare, AP. Next paragraph. Full stop. Papumpare, after filing of a charge sheet being CS number 11 of 2021. Sorry, not 130 of 2021, dated 11/10/2021. Next paragraph. Next, call for the scan TCR comprising case diary and charge sheet and other relevant documents from the learned court below, that is so and so. Next paragraph. Further, till the returnable date, further proceedings of GR number so and so shall remain stated. This is the matter after 3 weeks
3 weeks on receipt of my TCR.
on receipt of the TCR,
Yeah.
scan TCR.
Yes, sir. Deeply obliged.
Deeply obliged.
Item number 89.
May I please Lordship?
8 and 9, right?
Lordship.
Let's come up for admission.
Lordship, as per the last order dated 1/4/2026.
1/4?
1/4/2026. This honorable court has directed the petitioner to file an affidavit regarding the payment of rupees 2 crore. Lordship,
The 1/4, or I think it's 26/4.
1/4.
1/4/26.
Yes, yes.
Oh, sorry. 1/4.
1/4.
It's here. Okay. Let me go through it once. Let me go through it.
1/4/2026. Lordship.
Okay, I get
Ma'am.
it. So, sir, you have, you were given time till
Lordship,
4th August,
yes, yes.
3rd August.
Yes, accordingly, Lordship, the order and direction of this honorable court of 1/4/26 has been duly complied by the petitioner.
All the amount has been cleared.
No,
No.
Lordship. The direction given on 1/4/26 for depositing rupees 2 crore
2
Yes,
crores.
has been complied. Lordship.
What is the total amount? It's quite
Lordship.
huge.
My
It
lord,
seems.
now there's
It was it a money suit, madam? Money suit?
Lok Adalat award, my lord.
Okay, Lok
Lok
Adalat
Adalat.
award. Where is the award? I'll just flag it.
CRP 16.
Yeah, that was it. Lordship, page number 38 of criminal petition, CRP 17/20,
Yeah, I'm on 17 only.
page number 38.
38?
Yes, Lordship.
Okay, thank you.
May I please, Lordship?
Oh. So it arose out of money suit, basically. Settled in Lok Adalat.
No, my lord.
No, not money
It was
suit.
filed under Bengal Recovery Act.
Oh, I see.
Baki jaye.
I see.
Lordship,
That act.
my intention is, Lordship, very clear, Lordship. I am ready to repay back the money, but due to my financial problem, Lordship, I have already given my plot of land located at Jolang village to the opposite party, that is bank, Lordship. Now I am say this, which has been given as a collateral security, but the same collateral security was not been able to dispose by the respondent bank. Now the onus has been again shifted back to me for selling of that land. Now, Lordship, even in the affidavit I have mentioned my source of repayment. Lordship, I will repay back the money for sure, Lordship, which I am doing, Lordship. Lordship, but I need time, Lordship.
So, okay, I understand.
Lordship,
The total amount was 6 crore. It was settled at 6 crore
My lord, there's two accounts.
89, 39,000.
Yes, my lord.
This was
Lordship, in my
This one is in
17.
yes,
17.
CRP 17.
So this is one amount in 17.
Yes.
Out of this amount, how much has been settled now? 2 crore 70 lakhs.
No, my lord, in 17, no payment has been made. The payments that are been made is in CRP 16.
16.
Yes.
The order is
Lordship, it has been taken as a linked case. Both the case has been taken up together. The order has been passed in both the case as club. It has been clubbed.
Common order.
common
Common
order.
order,
Seems-
common order, Lordship. Now, Lordship, in my affidavit file on 4/8/2026, I have categorically stated all the abatements regarding the outstanding, regarding the award and all. May I take, Lordship, to my affidavit kindly, Lordship? Affidavit file on 4/8/2026, page number 170, Lordship.
170.
Yes, Lordship, page number 170. Details of loan recovery of the petitioner. As per the Lok Adalat award dated 9/3/2019, the first settled amount is rupees
Just a minute. Page 70.
170.
Oh, so 170.
Yes, in my affidavit, that
Additional affidavit.
additional affidavit file on for yesterday I have filed.
Got it.
Lordship.
170.
Yes, 170. Amount settled under Lok Adalat on 9/3/2019 is, Lordship, there is two account. One is rupees for settled amount is rupees 10 crore. And the second
10 crore. What is the
Yes, 10
amount?
crore,
10 crore.
only 10 crore.
10 crore in 16.
Yes. And in 17 rupees, 6 crore 88 lakhs.
39,000.
Yes,
Yes.
Lordship. Now the total sum is rupees 16 crore 88 lakhs 39,000. That is CRP number 16 and 17 both, Lordship. Now the repayment made so far is that on 4/5/2024, I have paid rupees 1 crore. Second repayment on 13/3/2023, rupees 29 lakhs 99,952. Third repayment is on 16/7/2025, that is 1 crore. Fourth repayment done is on 19/9/2025, rupees 70 lakhs fifth repayment made is on 14/11/2025, rupees 30 lakhs. Six times repayment made was on 11/2/2026 is rupees 40 lakhs. Now, the today's repayment that is on 3/8/2026 as per the order of 1/4/2026, the petitioner has paid rupees 2 crore. Now the total repayment made done so far is rupees 5 crore 69 lakhs 952 rupees. Now the balance repayment to be done is 11 crore 18 lakhs 39,048 rupees. Lordship, as I have already stated that Lordship, I am intending to repay all the outstanding by disposing my land, which I have already given as a collateral security, but the bank has refused to dispose of this land.
You claim the value of the land to be about 30 crores.
Yes, Lordship. That is, yes, that is 30 crore land value. Now I am selling partly and I am repaying the sale consideration amount which I am obtaining from the land. I am repaying bona fidely, Lordship. So I need time, Lordship. Today my prayer before this, Lordship, would be that within 3 months, I am paying 1 crore, which my clients are paying. And if they pay, then I will definitely repay back the said amount to the respondent bank. As of now, my prayer before this, Lordship.
You will pay all the 11 crores
Yes, I'll pay 11.
in 3 months.
No, Lordship. 1 crore, Lordship. In 3 months, 1 crore, Lordship.
But
Lordship.
That way, my lord, it will take
long time.
No,
very long time.
Lordship, at least in the next 3 months, I'll pay 1 crore. Lordship, the amount is too huge, Lordship.
No, you have you must have had,
And Lordship,
you must have taken, he took a loan or something?
Yes, my lord,
Yes.
he took a loan
yes,
in the year 2013.
that is
14.
admitted.
What is the loan amount?
Loan amount was,
This is the total after interest, right? The loan
my lord,
repayment.
the interest has been waived off. These are the
Wait,
loan amount,
This is the principal amount.
principal amount.
Okay, you here taken a huge loan. So
This
you, I mean, there's
consented
no option but to,
Yes,
transact that property.
Lordship,
That's
execution
for
has
you
been
to
ordered.
decide,
Yes.
but not for the court to say.
Lordship.
But still, and if you really think that it's valued at 30 crores, definitely that 11 crores can be taken out from that.
Yes,
Still, you will have a part of the land for yourselves. Still you have. So why pay 1 crores? You clear it.
Lordship,
Try to clear it within this year.
Lordship,
yes, my lord.
Lordship, there is some season for purchasing of the land also. Now it's a peak winter, monsoon season. So clients are not inclined to purchase the land, Lordship. That's why, Lordship. In the winter, Lordship, I will try to repay back all the outstanding amount, Lordship. As of now, at least, Lordship, 3 months may be given for payment of rupees 1 crore. Lordship, my intention also is very clear, Lordship. In the previous conduct also, Lordship can see.
CR number, this was the proceeding
Lordship.
Yes,
before the Baki Jai proceeding.
yes, my lord. CR number is the Baki Jai proceeding. My lord, this is the 7th year after the Lok Adalat award has been passed.
No, 19 is.
Yes, my lord. Bank has given a very long time to the
Yeah,
petitioner to
yes,
make
yes, definitely.
specified time can be given.
Yeah.
Common order, no? Common order. Full stop. Heard, Mr. Taba
Yes, Tita.
and Madam.
M. Karbak.
Learned counsel M. Karbak, learned counsel for the for the respondents being AP State Cooperative Apex Bank and its branch manager of Itanagar branch. With regard to a loan taken by the petitioner, there was a default.
Yes, my lord.
There was a default whereupon a proceeding being CR number DC/IC page 2, you can write it from here. It was initiated before the ESC certificate officer Itanagar Subsequently, the matter was settled before the Lok Adalat on 9/3/2019. And the settled amount was rupees 16 crore 88 lakhs 39,000. Within bracket, within bracket, 39,000 plus 10 crores. Both the learned counsels has drawn attention of this court, next paragraph, to order dated 1/4/2026 passed by this court. And by the said order, the petitioner was directed to pay another rupees 2 crores by 3/8/2026, failing which the matter was to be heard and disposed of on merits. Upon such payment, the petitioner was to also file a compliance affidavit. Next paragraph, in compliance with the same, the petitioner is stated to have made the payment of rupees 2 crores and submitted an affidavit, additional affidavit dated 4/8/2026, in which he has narrated all the payments made so far. With the first payment of rupees 1 crore on 4/5/2024 and the latest payment of rupees 2 crores on 3/8/2026. Full stop. It is stated in para 6 of the additional affidavit dated 4/8/2026 that so far, out of the total amount of rupees 16 crore 88,39,000 dash, give a dash, a payment of rupees 5,69,99,952 have been made so far. And the total outstanding amount remaining as on date is rupees 11 crore 18 lakhs 39,048. You make this figure bold. Full stop. Next paragraph. The learned counsel submits that he may be allowed to pay rupees 1 crore
Yes, yes.
within the next 2 months. Full stop. It is also stated in the additional affidavit that the petitioner has a property by way of land which is valued at around 30 crores, and that the collateral, it has also the documents have been given.
Yes, yes.
The documents of the said land have already been deposited with the bank.
No, my lord.
No?
The bank has returned the documents to the
Okay.
petitioner in the year 2023.
Okay. Were sought to be deposited with the bank earlier,
Yes.
but it is sought to be deposited with the bank earlier. Full stop. To this, the learned counsel for the bank submits that the documents were, however, returned by the bank.
Yes, my
Full
lord.
stop. As per the award dated, we have mentioned the date of the award, right?
Yes.
Award dated so and so.
9 March 2019.
9/3/2019.
Yes, Lord.
9/3/2019. The entire amount was to be paid within 6 weeks.
Yes, ma'am.
Learned counsel for the bank submits that there have been considerable delay in clearing the said amount, due to which the bank is suffering prejudice. Full stop.
No, no, settle amount to you again.
What you do is make a payment every month.
Yes, ma'am.
Instead of the court stipulating how much you should pay, you make it. You try to you have to monetize at least. I mean, there's no other option. It's such a huge amount. So monetize a part of your land. At least you have you're fortunate that at least your land is there, which you have frankly admitted. That's appreciable. So that is the only option. So best would be you make a regular payment every month and clear it within this year.
My lord, I pray for paying 1 crore each month and clear the,
Even then, it will not be clear. It'll say
Yes.
there's 11 crores, lot of money.
yes, my lord.
But it is can I record your submission?
Yes, my
It
lord.
is submitted by Ms. Tarak, Learned Counsel for the bank respondents that the petitioner may make a payment of at least rupees 1 crore every month.
Yes, my lord.
You make an endeavor.
Lordship, my respectful submission would be that since this is a peak monsoon season, my source of repayment is by disposing my land.
Hmm.
Now,
No, you have issued an advertisement also.
yes, Lordship, I have made an
The
advertisement.
Learned Counsel
Yes.
for the petitioner submits that even a newspaper advertisement has been issued inviting potential
buyers.
prospective buyers for the land. That's okay.
Yes. So Lordship, my submission for today would be that till 5/11/2026, that is 3 months from today, I am paying 1 crore. Thereafter, Lordship, after disposing of my land, if I'm able to dispose of all the lands, I will repay back the entire amount. But for today, Lordship, till at least 3 months may be given for repayment of rupees 1 crore loss. Because this is an off season.
The Learned
Definitely
Counsel
kindly
submits that
3 months.
the present days are kind of a off season for land transactions, especially high value land transactions.
Because
and-
of monsoon.
In this context, the Learned Counsel submits that he may be allowed to pay rupees 1 crore within the next 3 months, and thereafter, when the sale season improves, he would endeavor to clear the remaining decretal amount entirely.
Lordship, that is my submission. Lordship. But till 5/11/20,
February, my lord, he can pay the entire amount
that may not be.
before the end of the financial year, my lord.
Good, so next paragraph. Okay, that is, I've just recorded your submission. Because I think the court should not say you pay 1 crore. You should clear the amount. That's
Clear the
what we
amount.
should say, isn't it?
But my lord, if no specified time frame is given,
The
not be-
petitioner is, there are two petitioners, the same petitioner.
same petition.
The petitioner is allowed to make the payment indicated above within 3 months from today. That is within
5/11/2026.
within 3 months from today. Full stop. He is also directed to make full endeavor to pay the entire decretal amount on or before 31/12/2026.
Yes, my lord.
What else can we say?
Lordship, that may not be possible, Lordship.
You
Lordship,
endeavor, I'm saying, endeavor. You make the payment, otherwise,
Lordship, that may not be, Lordship.
because otherwise the bank can proceed against the land.
Lordship, as
My
per,
lord, the proceeding is pending before the trial court, my lord.
Hmm.
Because of this CRP, there is a stay.
Oh, I see.
Therefore, my lord, it is difficult for the bank also to take any steps.
that is just an execution petition, that is not regarding the disposal.
The execution is under stay.
Yes, my lord.
Stop.
It is a state.
It is submitted by the Learned Counsel for the respondents that due to the pendency of this of these two civil revisions, CRPs, the execution case number
4 of
EXP
2020 and 5 of 20.
5 of 2024 pending before the
Senior Judge
Civil Judge Senior Division,
Division,
UPR.
UPR.
UPA, is under an order of stay by order dated 29/4/2024, as a result of which the bank has not been able to proceed
Yes, ma'am.
with the same to recover the money. Full stop. So,
Lordship,
My lord, I pray that if the payment cannot be made in the month of February 2027, the matter may be disposed of.
that would be 2 hours, Lordship, because Lordship by intent
no,
is
it's,
very.
see that 19, award of 19, 7 years. Then the stay will be liable to, we'll have to dispose it of.
Yes, my lord.
The learned counsel for the bank submits that the petitioner may be given an outer limit of 28 outer limit of 28 to 2027 to clear the decretal amount, failing which the revision should be disposed of on merits.
Lordship, at least kindly make it as 30 April, Lordship, because financial year,
And the
it's an op-
upon giving consideration to the various aspects of the matter, some of which has been narrated above, it is hereby directed that the petitioner shall endeavor to clear the entire decretal amount by 31/3/2027, if not earlier by 31/12/2026. Full stop. Semicolon, failing which it would be open to the court to proceed with the revision. So it's okay. Enough time, 31st, you have a lot of time. You ran into a huge debt. But the loan was big. See, banks survive on this.
Yes, my lord.
It's not that, it's not their money. That's just the business. How will they, without repayment, how will the banks survive? That's also there.
My lord, a fixed date may be given for
Yeah, next date should be fixed after.
6th of November.
yes.
Yeah,
6th of November. 6th of November for filing the compliance of.
the petitioner shall file a compliance by the next date. List the matter on, let it be on 10th November.
Yes.
10/11. 10/11. Okay,
April.
let's take a short break.
Item number 1, passover matter.
Oh,
Your lordship, I'm very sorry I could not appear when the item was called for. Lordship.
no issues. You are appearing from Gauhati.
Yes, lordship. So it's a regular bail application, lordship. The petitioner was arrested on 15/1/2002, lordship, in connection with the FIR, lordship. That is at page 17, lordship.
Okay, it's 17.
It's a person there to the charge sheet was filed. Yes, lordship.
Online complaint by regarding my hacker. अच्छा. The allegation is the accused name
Person
is
there to the charge sheet was filed.
Shashit was filed.
Accused name. Yes, lordship. And he was arrested on 15/1/2026, lordship. Since then, he has been languishing in the bar.
15 arrested on 15/1/26.
15/1,
Yes.
lordship.
The case is
15/1/26.
Got it.
Yes,
The case is presently it's pending before
Chief Judicial Magistrate as per their electoral laws.
Chief Judicial Magistrate Papum Pare, lordship.
CJM Papompare. Is trial going on? Trial is going on, or what stage is? What is the stage of the case?
And
If you have
no,
information.
lordship. It is lordship. It is yet to be started, lordship. No court has been allotted till date, lordship.
Still with CJM.
Page 26,
Appearance.
lordship. Case is not allotted to the court.
Okay.
Yes, lordship.
We can get the case diary, scan case diary.
It's already charge sheeted lordship, then.
Sorry, no, it's TCR.
TCR lordship.
TCR. So, this, Papupare is here only.
Yes,
So we
lordship,
can,
it's right nearby.
yeah. CJM, Papupare, UPR.
Yes, lordship.
Oh.
Registry may call for the
Okay.
TCR lordship.
Third, Mr. Learned Counsel for the MK
MK
Bora, Learned Counsel, who has appeared online, assisted by Learned Counsel,
M. Sora.
who has physically appeared before the court here. Full stop. The petitioner was arrested on 15/1/2026 in connection with cybercrime PS case number 1 of 26 under so and so section. Full stop. The said case was registered based on an FIR dated
8/1/2022.
the date is not 8/1/2026, lost with certain allegations about with certain allegations. Full stop. The investigation of the case resulted in a charge sheet fight CS number 4 of 26 dated 23/2/2026. The case being, what is the GR number? You check out GR number. GR number 170 of 26 is pending before the court of the learned CJM Papumpare, UPR. Call for the scan TCR comprising case diary and charge sheet, and case diary, charge sheet, and other relevant material of GR number 170 of 20.
GR number.
List. Yeah, got it. 170 of 26. List on when? You can fix it. Monday?
Yes, lordship, next week, lordship.
On Monday?
Yes.
List the matter on Monday. That is, Monday would be which? 8, 9, 10. 10, 8. Okay, Mr. Bora? 10, 8.
Deploy.
You can log out.
Item number 11 to 14.
Oh, connected.
My lord.
Yeah.
This, my lord,
all are connected.
All are connected. It's arising of a contract, my lord. Contract. This two project, my lord. Basically, it involves a two project, my lord. The one project, my lord, project namely road from 7.5 point of Changlang Khonsa Road to Jhong Phate stage. It was awarded to one contractor, one firm, MS Konsi Enterprises, through tender process by.
Just a minute. Let's start with this. First, let us see the FIR.
My lord will see FIR at
page.
My lord, it starts from page 97, my lord. Basically, it was initially it was lodged before the Deputy Commissioner Changla, page 97, my lord.
The complaint.
Yes, my lord, complaint.
And the Deputy Commissioner, Office
Yes,
of the Deputy Commissioner forwarded it.
Forwarded, my lord. Forwarded, my lord, at page 98, next page, my lord. On receipt, this case was registered on 18/5/2026, my lord. Down below, and the formal FIR is at page 101, my lord. Upon receipt, my lord, this was registered on 8 May 2020.
Just a minute. Okay. So accordingly, this case was registered.
Yes, on 18 May 2026, my lord. The formal FR is at page 101, my lord.
Got it. The complaint was dated 6/8/2025.
25, my lord.
25. Thereafter, the FIR
Registered
was
on
lost.
Anti-corruption bureau, BS
ACP
case number
4 of 2026.
26, my lord.
26 of Itanagar.
May I please, my lord?
Under 120B.
May I please, my lord?
Just a minute, I'll come to you. You write down this. 467, 471, read with section 13(2) PC Act.
My lord, the case was not directly registered, my lord. In fact, after
Preliminary
there was
inquiry,
a preliminary inquiry, my lord.
FIR is
So
reflect.
section 17A of the
Yes.
PC Act, my lord. Thereafter, my lord, certain
Yes.
anomalies will found, my
The
lord.
FIR
And
was
then
lost, preliminary inquiry was made,
Yes, my lord.
and thereafter,
Thereafter, the FIR was registered. It was
registered. Therefore, it was
registered.
Yes.
My lord. That's the case.
Yeah, as per the
That
procedure.
FIR, my lord, it's reflect, my lord. At page 102, my lord.
I got it.
That's
So these were the allegations about.
yes, my lord. Now, based on this, my lord, after registration, my lord, in this connection, my lord, page 103, my lord, this relevant document that was sought for, my lord, I've submitted, my lord. This is present incumbent, the executive engineer submitted, my lord, all as per requirement. Now, he's cooperating, my lord. And basically, my lord, this is, my lord, all about the two projects basically involved. One project, it was awarded to one Consi Enterprises by contract agreement through open tender on 11 July 2017. And other project, it was awarded to one MS Sabuddin Siddiqui on 16 September 2019, my lord. My lord, just I'll take even the NIT also, my lord, NIT and acceptance and entire tender contract agreement. There's a mechanism to deal with in case of a breach of contract by the contractor. There's a mechanism to recover as to how the liquidated damage and loss if caused to the employer. It can be recovered. There's a mechanism under contract agreement.
And who are the petitioners? They're the officials.
The official, my lord.
Public servants.
I was posted as the item number 11. I was posted as an executive engineer during 2001 to 2023, my lord. I'm no more executive engineer in their particular division, my lord. And item number 12 is, my lord, it was on 25, my lord. My lord, if I take, my lord, the even contract agreement, my lord.
Oh, now I am on the file. All the files are here, of course. AB 1575.
1575, my lord. It's initial.
Sorry, it's a new number. AB 81. I am on with the first one. Item 11, AB 81.
Yes, my lord.
Okay, you are on that file.
Yes, my lord. On the same. My lord, this all the facts are similar only, my lord. The first, my lord, NIT in respect of first case, which was awarded to MS Consi Enterprise, my lord. NIT, it was through NIT, my lord. Page 28, my lord. NIT will, my lord, see. Page 28, my lord. It is the NIT dated 20 January 2017 for construction road from 7.50 km, my lord.
There is only one NIT?
Yes.
Only one NIT.
One NIT, my lord. Pursuant to this, my lord.
All the works were to be undergone.
30, my lord.
Undertaken.
It was awarded to the once Consi Enterprise on 30 June 2017, page 30, my lord. And based on this acceptance, my lord, letter of acceptance, contract agreement was executed, my lord. Contract agreement, my lord, we'll see at page 31 to 50, my lord, 54, 31, contract agreement. Based on this contract acceptance letter, page 31, my lord. It's a contract agreement.
After getting the contract, this
Yes.
agreement was executed.
Executed with the one Consi Enterprises
Who got
contractor.
the,
Yes,
who got the,
the
who was
tender.
awarded the contract?
Yes, my lord. Now, under this contract agreement, my lord, my lord will see at page 48, clause 44. The provision contractual condition term has been incorporated as to how to deal with the in case of breach of contract, my lord, at page 48, my lord, clause 44. Liquidated damages, my lord. Page 48, my lord. Clause 44. It says, my lord, in the event of failure on part of contractor to achieve timely completion of the project, including any extension of time granted under clause 27, he shall, without prejudice to any other rights or remedy available under the law, the employer on account of such breach, pay as per the
Agreed liquidated damages.
yes, madam, damages to the employer, and not by way of penalty like this, madam. There's a provision for recovering, my lord.
This, I think, the sentences follows, does it follow sequentially?
Damages to the employer
And not by way of
and not
penalty.
by way of penalty, madam.
In the sum calculated that so and so, so and so. For the period, the completion date is later than. However, in case the contractor achieved the next milestone, amount of liquidity already withheld shall be restored. Both the parties agree that the total amount of liquidated damages shall not exceed 10% of the initial contract price, and that the liquidated damages payable are mutually agreed generally without any proof of actual damage line. Okay.
Now, after termination, madam, termination deals with clause the provider under clause 52, 53, madam, 50, page 51, madam, you see. Termination, madam, termination clause. After termination, there's a other way, madam, as to how this, even the property can be
Page
51, madam.
51.
51, clause 52, madam, under contract agreement.
Termination.
Employer may terminate a contract if a contractor causes a fundamental breach of contract, madam. That's what are the branch, fundamental breach of the contract but shall not limited to the following, madam. This has been there. And after termination, madam, page clause 53, madam, down below, madam, payment on termination.
Okay.
Payment termination. If the contract is terminated because of the fundamental breach of contract by the contractors, the engineer shall issue a certificate of the value of the work done, less liquidated damages and less percentage to apply to the value of work not completed as indicated in contract data. If the total amount due to the employer exceed any payment due to the contractor, difference will be recovered from the security deposit and the performance guarantee. If any amount is still left unrecovered, it will be debt payable to the employer from the state.
Employer means the department. The department.
Yes, ma'am. Now the other
from state, okay, any other work.
Any other state work, including the public. It can be even if he's working, the contractor is working any other, not irrespective of the not necessarily that should be under particular division within the state, if they're working, that can be recovered, and 53.1, contract, if contract is terminated, breach of contract due to non-completion of the requirement under also defect liability. And now importance page the clause 54 also there. Page 54. Apart from this thing, even the materials on site, tools and plant will be vested upon will be confiscated by the department. Page, clause 54, property. All material on a site, plant, equipment, temporary works and works shall be deemed to be property of the employer for use of completing balance construction if the contract is terminated because of the contractor's fault till the work is completed, after which it will be transferred to the contractor and credit, if any, given. This even a property. Now, this is in respect of the one project executed on 11 July 2017, awarded to one MS Consi Enterprises. Now, second contract, will see notice inviting page 55, my lord. Page 55, my lord. Notice inviting that at 22 September.
This is another NIT.
Yes, another NIT, and through which this is another project that's given to another contractor, that is Sahabuddin Siddiqui. This is the this particular project named road from 6.50 km Changlang Konsa Road to one. This is the NIT, my lord. And based on this NIT, my lord, at page 59, after thorough process, work was awarded to MS Sahabuddin at page 59, my lord. It's awarding my letter of acceptance. Page 59, my lord. It was awarded to Sahabuddin Siddiqui on 10 September 2019. And pursuant thereto, my lord, the contract agreement was signed. My lord, say at page 60, contract agreement, 60 to 68, 60, my lord. Now, under this contract agreement, signed with the once Sahabuddin Siddiqui in respect of the other project, my lord. Under this contract agreement, clause 44, my lord, page 78, my lord, is deal with same as how to deal with recover, my lord, recovering purpose, page 78, my lord. 78, my lord, clause 44, my lord. Liquidated damage, my lord, same language, my lord. In case of failure on part of the contractor, my lord, there's a provision to recover liquidated damage from the contractor. And under this contract agreement at page 79, my lord, clause 45, even there's a provision for making advance payment, my lord. The purpose is that the work is done, my lord, to ensure that, my lord, with clause 45, even advance payment can be made, my lord. Clause 45. On request of contractor, page 40 clause 45.1. On request of the contractor, employer will make the following advance payment to the contractor against the submission of contract of the unconditional guarantee, bank guarantee from the scheduled commercial bank acceptable to the employer, an amount equal to so and so. This mobilization advance up to 5% of initial contract price, excluding the contract price for routine maintenance, and equipment advance up to 90% of the cost of the new equipment brought to the site. That advance payment can also be made. And in that case, in case of there's a provision, page 82, clause 52. 82, my lord. It deals with the termination clause, man. Page 52, termination.
Like that one.
Like same, yes. Same. And thereafter, my lord, at page 83, my lord, upon payment upon termination, my lord, page 83, clause 53, my lord. After termination, what has to be done, my lord? Contracts 53.1, clause 1. If the contract is terminated because of the fundamental breach of the contract by the contractor, the engineer shall issue a certificate of well. Same language, my lord. There's a provision of recovering, my lord. And now at page 84, my lord. Property, that also even property can be seized, my lord. Page 84, clause 54, my lord. Property. All material on site, page 84, clause 54.1. All material on site, plant, equipment, this is after termination, temporary work. Work shall be deemed to be a property of the employer for use of completing balance construction work of if the contractor is terminated because of the contractor's fault, till the work is completed, after which it will be transferred to the contractor and credited, if any, given for its use. Now, this is, my lord, under the contract agreement, there's a mechanism, my lord. Now, as of now, but this, although the completion period expired, but officially contract agreement has not been yet terminated because they have not completed the work matter. It's still it is enforced matter. Now,
the allegation is that it has been shown as completed payment made, but actually not completed.
not completed.
That is
But
the
this-
allegation.
Yes, but that is a fact. That is, there was even no physical completion certificate issued from the department, my lord. It was only shown in the OMA's website, my lord. That may be a technical default, my lord, fault, my lord. Now, present this applicant, my lord, is posting period, my lord. He was there as the executive engineer from 14 July 2021.
In this petition, there's one petitioner.
Yes, my lord.
One petitioner in each of the petitions.
Yeah, my lord. This is similar, same only, my lord. The first petition, my lord.
First petition, Bingdung Rido.
Yes.
Hello.
And he was there as the executive engineer from 14 July 2021 till 26 May 2023, my lord.
From?
From 14/07/2021
to
till 26/05/2023.
Executive engineer.
Yes, executive engineer. In charge of particular division. Now, this page 91, my lord, so-called notice was has been issued by the present incumbent executive engineer at page 91, my lord, against Sabuddin Siddiqui. That
The present E
yes,
issue the so-called notice.
yes,
To the contractor.
to the contractor, my lord. As to why that action should not be for recovering liquidated damage and termination, my lord. That provision clause 4452 of the contract agreement, my lord. On 20 April 2025. my lord. And against this, my lord, since there's no appropriate response from the contractor, my lord, at page 92, my lord, the approval was sought for from the competent authority to terminate this contract agreement with the Sabuddin Siddiqui, my lord. My lord, his tools and plants and the
Okay.
this, my lord, the second last paragraph, the approval was sought for, man, for termination of this Sabuddin Siddiqui, man. There's certain amount, man, that the incumbent present executive engineer has worked out the around 1.6 crores, man. That is already there, man, against this contractor, and it is also, man, it's not that he has also executed certain project against the same division, and on after calculating, exercising, carry out, madam, there are around 2 crores plus the already amount. It is at the disposal of the department now. Now the requirement for the completing this project is, my lord, 1.5, my lord, additional fund, madam, as per this letter, my lord. Now the present contractor, the amount which can be recovered and at the disposal of the departments, more than 2 crore, and including the tools and plant, it comes up to 3 crore plus, my lord. And through that money only it can be also done, my lord. But since approval has been sought for, my lord, awaited. Now second at, my lord, page 94, it is against another project, my lord, which was awarded to Consi Enterprise. It was so-called notice was again issued to the Consi Enterprise on 10 February 2026 by the present incumbent, my lord.
Another project.
Yes, another project. That is also as to why the contract should not be terminated and action liquidated damages should not be recovered as per the contract agreement. Page 94, my lord. This was so-called notice issued to the Council Enterprises. My lord, in response to this so-called, the Council Enterprises, my lord, has submitted a written undertaking at page 95, my lord. This type copy, original is 96, my lord. Type copy 95, my lord. They have submitted written undertaking that assuring that he will complete the project by 30 September 2026, my lord. And if it is not done, my lord, as per this undertaking, my lord, as per the contract agreement, it will follow, my lord. The mechanism is provided under contract agreement. And when this, my lord, contract agreement was enforced, my lord, being enforced, and the step for taking action under the contract agreement was being undertaken by the authority, my lord. This at the complaint dated 6 August 2025, my lord, page 97, as we have already read from 97, my lord. It was lodged before Deputy Commissioner against these two projects, my lord.
Okay.
This is the fact. Now, based on, my lord, the earlier, my lord,
The other petitions also facts are similar.
yes, same, my lord. Same, my lord.
But the different projects,
Only, yeah.
different NITs.
No, my
No,
lord.
same,
Same NIT.
Same NIT,
Only the
but different projects.
no.
Two projects, my lord.
Two projects.
Same.
Only the officers are different.
Officers are different.
Yes, government officers. Yes.
Who participated in different
Yes.
segments
One
of the
was
work.
Assistant engineer.
Yes.
One was.
Same NIT and the works are same.
My lord, in this regard, my lord, just
But they were involved at different stages.
yes,
The petitioners.
Yes.
And different in India, different positions.
In different capacities.
Got it.
Official capacity.
Got it.
my lord, just I rely one decision of the Honorable Supreme Court regarding similar nature, my lord.
All of them are on interim bail.
Yes, my lord.
Yes, Lord.
My lord, this is Honorable Supreme Court says, my lord, in case of breach of contract, my lord, there cannot be criminal, but it cannot be converted as a criminal color, my lord.
Yeah. Only breach of trust cannot be.
Yes, my lord. My lord, here, my lord,
Dishonest intention is shown right at the beginning. Yes.
my lord. My lord, here all the mechanism is there, my lord. The contract has not yet been terminated, my lord. It's purely under the domain of the contract agreement, realms of the contract agreement, my lord. There's a mechanism, my lord.
Yeah, that's fine.
And other my lord, in similar allegations, similar FIR, my lord, the other co-accused that has been granted bail, my lord. On this, that the Honorable Supreme Court says, my lord.
If the factual matrix is similar, then
Yes, similar, my lord. Same FIR, same, my lord. That's my lord.
they have been granted.
Arising out of same FIR. my lord.
Okay. Another person has been granted anticipatory bail in.
Two of them has already granted.
Absolute.
Absolute, my lord.
Okay. You have the orders.
My lord.
You have the orders.
My lord.
Or you give the numbers. I'll have a look.
Nirmal Sharma Chaudhary, my lord. This arising out of same, my lord. Same FIR. AB number 76 of 2026, order dated 21 July 2026, my lord.
This was arising out of the same
Same
work.
FIR,
Same work.
same case, my lord.
Same case.
And my lord, in this case, pursuant to the interim order, my lord, interim protection, my lord, the even bail bond has been executed, my lord. As per instruction, my lord, the bail bond challan, my lord, have been furnished, my lord. This item number 11, 12, my lord, the bail
That's all.
bond, as per the interim order,
That's
even bail
okay.
bond.
No problem. Okay.
Therefore, my lord, it's my respectful submission, my lord. Since it is under the contract agreement and the authority is, the action is being taken to deal with the contractor as to how that work can be done, my lord, as per contract agreement. Therefore, my lord, my respectful submission, my lord, my interim protection might be made absolute, my lord, because there's no, my lord, chance of even absconding, my lord.
Okay.
The applicant is government employees, my lord. That's my respectful submission.
Okay. Now, what about the other?
Yes,
You adopt the submissions?
Same, lord.
My lord, the CD is here, my lord.
Just a minute. It is up to item 14.
Yes, yes. 14 and 14, my lord says on 37, 2026, teaching protection was started.
Yes. This was the 11 and 12, 15-7. 15-7.
Yes, my lord, 15,
15-7 and 12 and 11 and 12, 13 and 14 on
37, lord.
30.
30. Accordingly, lordship, on 3rd, we appear before the support officer in terms of
Many.
comply.
Yeah. You make your submissions. I'll see the case diary later on.
My lord, my friend has argued on the contract, my lord, between the employer and the contractors. But my lord will kindly appreciate, my lord, this is there are two contracts, my lord, and one costing around 7 crores, my lord, and one costing around 5 crores, my lord. Now, 3 crores, my lord.
Two contracts.
Yes, two contracts, my lord. And it pertains to the maintenance, my lord, of the road, my lord, and it is for the public interest, my lord.
What has exactly happened as per the department?
As per the department,
As
my
per the
lord,
investigation?
it seems, my lord, as per the investigation, my lord, in certain work has been done. In the first phase, my lord, they said that all the works have been completed, my lord. However, on a physical visit, my lord, it seems like nothing has been done, my lord.
Nothing.
Nothing in a sense that it has not been completed.
Very incomplete.
Yeah, very incomplete. And only, my lord, 30 lakhs is remaining, my lord, out of the 3.3 crores, all paid, my lord. And as far as the second contract is concerned, my lord, there was 7 crores, my lord. Out of that, my lord, 50%, only 50% of the work has been completed, my lord.
Okay.
But all the funds have been released, my lord. And
Except all the funds. have
yes,
been
my lord.
released.
And they have
Out of 7 crores?
yes, my lord.
How much approximately?
Approximately only 50% has been done, my lord. As per the CD, my lord.
3.5 crores left.
No, my lord.
50%.
Only 50% of the work has been completed.
Okay, 50% work and money released?
Money released that I'm.
I have to check.
Yes, my lord.
Folks.
However, my lord, completion certificate.
And the earlier one, the amount of value was 3 crores.
3.3
Approximately 3 crores. And only 30 lakhs remaining.
Only 30 lakhs.
And the work is?
Normally, they say it has been completed, but then
Actual visit,
nothing.
reveal only a percentage.
Yes.
Say how much approximately?
Approximately, it might be around 30 to 40% of the work. So, my lord, with this amount which has been left, my lord, this work cannot be completed, my lord. So, and in the other one.
So, money has been released, but work has not been done.
Work has not
That's
been
the
done.
crux.
That is the basic allegations, my lord. And in the second contract as well, my lord, only 50% work has been done. However, it shows it is completed, my lord. That is the issue, my lord. Now, as far as the contract is concerned, my lord, whether, as argued by my learned friend, my lord, whether it will come under the contract or not, my lord, it is the public money is involved, my lord. There may be a contract, my lord, between the government and the contractor, my lord. But then, since the officials are involved, my lord, and it involves the money from the government execution, my lord, and it's a loss of public money, my lord. Therefore, my lord, and if my lord sees the there is the CD, my lord. Page number 3, my lord, the role of
The IOS submitted a status report.
is status report, my lord. Is status report, my lord, page number 3, my lord.
Let me write down the names of the persons.
Yes, ma'am. My lord,
Okay.
My lord, at page number 3, my lord. Serial
the-
number 2.
Of the CD?
Yes, my lord. No, not the CD, my lord. The status report, my lord. Oh.
Yes, status report.
Yes.
I'm on page 3 of the status report.
Page 3, my lord.
Individual roles have been
Yes, exactly.
described.
Yes, my lord. My lord, kindly peruse it, my lord. And engineer Sanju Gyade was the JE at that point of time, my lord. He was the JE, my lord. And he has filed this petition, and he is the petitioner in item number 14, my lord. 14, 1-4. And 3, my lord, Sri Ponya Lolen, he was the then AE, RWD Changlang. And he is the petitioner in item number 13.
Got it.
And Sri role of Sri Bindum Rido Alo was the executive engineer at that point of time. And he is the petitioner in item number 12. And
11.
oh, it's 11. Oh, sorry, 11, my lord. And Sri Hankim Rekum was the then executive engineer. He is the petitioner in item number 12, my lord. And my lord will kindly appreciate, my lord, this project, my lord, the project number DPI, the first project, my lord, the tender was floated, my lord, in the year 2017, my lord.
Way back in 17.
Yes, my lord. And still now the work has not been completed. That's
8 years, 9 years.
Yes, my lord. And the other contract, my lord, it pertains to 2019, my lord. So that part has to be seen, my lord.
Preliminary inquiry report is there, no?
Yes, my lord.
It's there.
My lord.
In the case diary?
No, it is not in the case study, my lord, but it is in
It's an annex petition.
Yes, my lord.
Yes, yes.
Therefore, my lord, and my lord is well aware that this case is in its very initial stage, my lord. Now, the statement of the petitioner number in item number 11 and 12 has been taken, my lord. But we are yet to, they have been arrested and they have been released, my lord. But their statement
not
is
yet
not
recorded.
yet recorded, my lord. And my lord, this statement of the petitioner in item numbers 13 and 14 is yet to be recorded, my lord. Therefore, my lord, in my humble prayer, my lord, I humbly pray, my lord, the application may be rejected, my lord.
Part dictation. Take the part dictation.
What's the time for the complaint?
Yeah, that's a your for complaint. I have to hear you then. Yes, please.
How? It will be in the text as well as some law.
Okay. Who are you? You're a citizen.
Yes, I'm the complainant. I'm the BJP Mandal president.
That's different, but you're in your capacity as a citizen, you file this.
Lordship, I'm the local also.
Mhm.
Lordship, here, first thing is they were summoned under section 94 of PNSS, which is for only documents. So maintainability, whether they have to show that there's a reason.
No, it's okay. No,
That is one thing.
no, they are arraigned as accused in a cognizable offense, non-bailable, so they can apprehend, arrest anyway.
And another thing with Lordship was submitted by the learned SPP that 2017 and 19 NIP, till now work is not done.
That's a sad part actually. 2017 and
17 and 19 and period was, the period for completion of work was only for 12 months.
only 12 months.
Yes.
But still, so much time has elapsed.
My allegation wasn't against the officials. I only complained to the DC.
About the issue.
Yeah, that still now we are facing problems.
Yes.
Under this circumstances, under this uncompleted work, I have only that complaint to the DC. DC have forwarded to the.
Yes, yes. He has done that part, remaining part.
That will matter.
And just part dictation. Heard the respective learned counsels for the petitioners, for ACB, special PPACP, and learned counsel for the informant. By this common order, the aforementioned bail petitions are being disposed of. The applications were filed for seeking pre-arrest bail in connection with ACB case, Anti-Corruption Bureau, ACB PS case number 4 of 2026 under section so and so. You take it from the order of 15-7. Full stop. The gist of the allegations is that a complaint was lodged by the respondent number 2 informant, alleging irregularities in execution of 2 PMGY road projects under the Department of Rural Works in Changlang division of the state. There were allegations of misappropriation of government funds, incomplete execution of works, despite release of payments and issuance of completion certificate, though the works were not complete. On the basis the complaint was made to the office of the learned Deputy Commissioner, Changlang District, and subsequently it was forwarded to the ACB. And after conducting a preliminary inquiry, the aforementioned case was registered, also giving sections of the PC Act, apart from those under IPC. Full stop. While order dated, we have to write this thing. The petitioner, Bindu Rido Alo, and within bracket, AB 157, AB 81 of 26 is stated to be an executive engineer, Rural Works Division.
Yes.
Working in works of the state, Rural Works Division. That will do. Full stop. The petitioner, namely so and so, in AB, so we have to write. All are in item 12, he is
11 is executive engineer, 12 also executive.
executive engineer, 12, and 13, 14 are assistant engineers.
13 is the
13
assistant engineer.
assistant engineer, and 14 assistant engineer, junior engineer. Full stop. Full stop. Wide order dated 15/7/2026. The petitioners, Bingdung Rido Alo, and the second person, Hang Tim, in petitioner in item 12, okay, were granted interim pre-arrest bail with conditions. And the case diary was called for. The cassette scan case diary is received. It's scan, original, scan. Original case diary is received by the learned special PP and is produced before this court. So the learned counsels submit and that the matter is essentially about breach of contract on the part of the contractor, for which there are detailed guidelines about the steps to be taken. In this regard, the Learned Counsel has taken the court to the relevant documents and submits that the same throw light on the steps and course of action to be taken in case of incomplete work or any breach of contract on the part of the contractor. It is submitted that in the instant case, some steps on those lines, such steps on those lines have already been taken, and steps are being taken to complete the remaining work. Out of the remaining work in terms of the tender. Full stop. The Learned Counsel submits before this court copy of order dated 21/7/2026, passed in AB 76 of 2026, in which a coordinate bench of this court was pleased to grant anticipatory bail to an accused, namely Nirmal Sharma Chaudhary, in connection with the same case. Full stop. The Learned Counsel for the petitioners also cites two decisions of the Honorable Supreme Court being so and so and so and so. You just right. Referring to these decisions, it is reiterated and submitted by the Learned Counsels that mere breach of contract cannot invite criminal liability, and that to invoke criminal liability in the context of breach of contract, fraudulent or dishonest intention has to be present right from the inception. It is submitted that the same is not at all the case in the instant matter, and that, as already submitted, it is a case of contractual breakdown and breach of contractual obligations, for which steps are already being taken in terms of the stipulated guidelines. The Learned Counsels praise for I forgot one line. Listen. The petitioners in AB so and so, namely so and so, 13 and 14, were granted interim anticipatory bail on 3/07/2026. Full stop. Summing up the submissions, the Learned Counsels pray that the interim bail granted to the petitioners may be made absolute. Full stop. Next paragraph. On the other hand, the Learned Special Public Prosecutor, placing the case diary, has drawn attention of the court to the status report prepared in detail by the IO and annexed with the case diary. Full stop. In the said status report, the IO has indicated some findings with regard to each of the petitioners separately. Full stop. The Learned Special PP points out that the NIT pertaining to the work was of 2017 itself, and still the work is not being completed. Full stop. It is submitted that despite the elapse of such a long time, the work has remained incomplete, and significant amounts of money, but significant amounts of money have already been released. Full stop. The Learned Special PP opposes the grant of anticipatory bail. Next paragraph. The Learned Counsel for the informant submits that in terms of the NIT of 2017, the works were to be completed within 7 months, and even after 12 months, and even after elapse of such a long time, the works remain to be completed. The Learned Counsel for the informant, as well as the learned special PP content that the question is also about involvement of public money and its wastage. Full stop. I'll go through the case diary once. No? I need to go through the case diary. I'll return it to you.
Okay.
That's all. Time is up. Finished orders after lunch.
Yes.
Yes.
What we are adopting, I think item number 24.
24.
24. In the morning, I was laying my bag in the photo. This matter will fix up day after tomorrow now, in the admission column, because PCR has been already received. But consent has been also obtained from there.
Learned counsel for the petitioner, item 24. Submits that TCR has been received in the meantime and prays for listing the matter
Yeah.
on Friday, that is 7th. Praise allowed. Any interim order? No.
Yes.
Interim order by so and so date stands extend. Next date of list.
Big deal.
Yes. Santosh, let's keep this. Huh? Oh, no. This time, no.
Item number 15 and 16.
And on last occasion also, my lord, the appellant counsel was not present.
Not present.
And yes, my lord, and the service upon responding over is still awaited, my lord.
It's still awaited.
It's still awaited, my lord.
Mr. Nair had appeared.
Yes, yes, my lord. And even, my lord, the suspension has been sentence has been suspended by this honorable court.
Okay.
I will inform them so that on next day they appear, my lord.
None appears on call on behalf of the appellant. He's appearing in both the cases, Mr. Nair.
Yes, yes, my lord. Yes, they are cognate appeal, my lord.
From earlier orders, it's found that Mr. P. D. Nair, the counsel, was representing the appellants. Full stop. The original case record
Yes, yes.
has been received. And
Paper book also prepared.
paper book is also ready. Full stop. However, service upon respond number 2 is still not complete. As still awaited as per latest office note dated 3/8/2026. So should we direct fresh steps?
Yes, my lord. That will be
Otherwise,
better.
there are no option.
Yes, I will inform them. my lord.
The petitioner, the appellants shall take fresh steps upon the respond number 2. Steps may be taken through the registry
Yes, my lord.
and to be executed through the concerned police station.
Yes, yes, my lord.
Or through office of PP.
No, my lord. Through jurisdiction.
Concerned police station.
Yes, yes, ma'am.
And subsequently, the prosecution shall take instructions regarding such
Yes.
service so that the appeal can be proceeded with.
Yes.
Full stop. List. List the matter after
3 weeks, my lord.
after 3 weeks
Yes.
on date to be fixed by registry.
Deeply obliged, ma'am.
Item number 17.
Original record. In the earlier one, original record. Original, because if you mention original and it's found to be scanned, so sometimes they'll keep on searching.
Okay, man.
This is scanned. Oops. Interim order was also to be considered. Criminal petition against for judgment. This is a concurrent findings of bill.
My lord,
Actually, concurrent findings of guilt.
yes, my lord, this revision actually, perhaps they have not succeeded before the
Yes, yes.
session court also.
Uh,
It's
concurrent
NIA case, my lord.
enact.
NIA case, my lord. The state is, we are just a pro forma party. Otherwise, my lord, the complainant should be the.
But service is not complete. Service is not complete.
My lord, but in this cause list, my lord, the respondents' name are reflecting, council names are
Is it?
reflecting.
Oh, yes, yes. You're right. Second copy. None appears on call. Um, The matter was last listed on 16/2/2026 when Mr. T. Tai, learned counsel, had appeared for the petitioner. Okay. And the said order also reflects that Mr. D. Sora, Mr. D. Sora, learned counsel, had entered appearance on behalf of respondent number 2 and had taken some time for filing objection. But it appears that no such objection has been filed. Not necessary of their objection.
It's
on the record.
adjudicated basing on record.
Yeah, exactly. The scanned TCR has been received. Do we have only the appellate order or whole records? We need the whole records.
We need the whole record, yes, madam, from the trial court.
Can you check it once?
Yes, madam.
Because otherwise, because we need the, not just appellate, we need the whole record.
Yes, yes.
Though the scanned TCR has been received, but CR 51/21, 2018, we have to have. Yes, you are appearing online. No, this is another matter.
Here, my lord, only
No.
record from judicial magistrate first class has been received. And that too, my lord, the photocopy, original has to be called for, my lord, since it is disposed of.
The record, it is submitted by the learned additional people, Mr. Ate, that only the scanned copy of the record has been received from the court of the learned CJM UPI. The
MFC, my lord.
Original JMFC.
Yes, madam.
The original case record of CR case number 51 of 2018 and criminal appeal number 7 of 2025 shall be requisitioned from the court of the learned JMFC, Papumpari, UPI.
Yes, madam.
Full stop. Please the matter after 3 weeks.
3 weeks, madam.
Matter number 18.
My lord, in item number 18, my lord, it's an appeal against conviction in a POCSO matter. And on last occasion, my lord, will find in order dated 5/2/26 that LAC was, my lord, directed to file appropriate application for condonation of delay as well as for of memo of appeal, my lord. The same is not yet filed as on that, man.
Mori Bagra was
Yes.
upon. Original record.
Even the TCR has been received and this court has directed them to prepare, my lord, the memo of appeal as well as application for condonation of delay, my lord.
As observed in the order dated 28/10/2025, there is a delay of 876 days in preparing this appeal. Mr. Morik Bagra, learned counsel, was appointed as legal aid counsel to represent the 876 or 87 days, I think.
My lord, we'll find the order in 5/2, my lord, the latest order is 5/2/26, my lord. 5 February 2026. 5th February.
It's written 87. But the previous order 876. Twenty-nine four.
On 2810, the parts order is 2810 and second is my lord 5226.
Don't mention the delay. No. There is delay in preferring, just write like that.
87 days delay.
However, the said learned legal aid counsel is not present today in the court district. He was also directed to file a delay condonation petition as well as appeal memo. As the same has not yet been done, it may be done so by the learned counsel. You can kindly inform.
Yes, my lord. My lord, the registry can, my lord, inform the legal aid council also, my lord.
The registry shall do the needful for informing the learned legal aid counsel, Mr. Bagra. The original TCR has been received in the meantime. We direct preparation of a paper book.
Yes, my lord. My lord, yes, that can be done, my lord. But the
delay
victim imprisonment is also there, my lord, in FOCSO method.
Delay has to be condoned.
Yes, yes, my lord.
Delay has to be condoned.
Yes, my lord.
Let this matter be listed after
2 weeks, my lord.
2 weeks.
2 weeks.
2 weeks, after 2 weeks.
Obliged, man.
Item number 19 and 20.
Yes. No, I have not directed preparation of first it has to be condoned, then admitted, then only.
Mayor Lordship, here as per the last order, I have taken a dusty service to the respondent number 1 and register post to the respondent number 2. However, despite complete of this dusty service to the respondent number 1 today,
None is appear.
None appear.
Just a minute, I'll
In regard to the
dismissed. See, this number 6. The appeal was dismissed.
Dismissed for
You're seeking restoration.
restoration.
And what is the miscase? Other miscase?
One miscase is for restoration of the IA and one is for the main appeal. In IA,
the IA is for restoration of the appeal. The appeal was dismissed. You file IA 1 of 26 for just see the prayer portion.
Your Lordship, I filed 2 miscase, one miscase for main appeal and second miscase one for the restoration of the IA 195 of 2022.
That was pertaining to?
That was in pertain to the when the appeal was filed, the judgment was stayed.
So you have taken dusty service on both?
For respondent number 1.
No, on both the petitions, both the IA.
Both the petition I have checked.
The petitioner herein is seeking restoration of MSc appeal number 13 of 2000 AP of 2022, along with IA number 195 of 2022, within bracket you write, which was filed for stay of the impugned judgment, pending disposal of the appeal. Both were both the appeal and the IA were dismissed for default by the order dated 25 to 2026. How many respondents are there?
2 respondents are there.
2 respondents. Two should be easy to serve. Insurance company.
Insurance company.
It has come.
Taken a registered post, but
your good name, please.
T. Nima.
Alia T. Nima, learned counsel, submits that as directed in terms of the order dated 26/3/2026, justice service was resorted to with regard to R1 and compliance affidavit has been filed. You filed a compliance affidavit,
Yes.
right? However, none has appeared on behalf of the said respondent. In view of the steps taken by the petitioner, including the filing of the affidavit, service upon respondent number 1 is taken to be complete. It appears that service report with regard to R2, respondent number 2/insurance company has not yet been received. We wait for some time? Wait, list after 2 weeks.
Keep top line.
Same order in both the cases. Same order.
Item number 21.
My lord, in the earlier line of litigation, the direction was, the liberty was given to both the party to approach the appropriate forum, either civil courts or inter-village territorial court. However, in spite of there being no complaint, Sumoto, the GAM secretary has issued the parwana. So I'm challenging that.
Okay. So what happened? You said they had an earlier round of litigation.
Yes, that
It
is
was,
order page 70 of my.
Okay. Then it was, they were relegated to seek their remedies before appropriate forum.
Yes.
And
Both the
thereafter, unilateral complaint was filed.
No complaint was filed both the parties. However, the head Gambura on his own issued the parwana,
Okay.
saying that the High Court has directed me to issue parwana.
Page 70.
78.
Today
Is
it
the
has
last
come up for, what is, let me see.
order.
Quiero ser de poco. Ito ang kondiso de. Ano ang umoti? Original ang magdila.
Yeah, that's order.
Order initiative, page 70. Pare. Impugn or 26.
My place, Lord, sir.
Just a minute.
Sixty-four to
Ko parwana hile. Yala. Parwana. Petition ni President. 16/12.
So now the respondents have also appeared, represented by learned counsel. They were asked to approach the inter-territorial customary court directly if necessary.
yes.
They belong to
My
different
lord,
villages.
at page 68, paragraph 18.
Do
is
they
the
belong to different villages?
It was
page
in
6.
first round of petition, Lordship, challenge was being made against the order passed by the affiliate authority.
Which is?
Affiliate authority,
Affiliate-
inter-village territorial
Oh.
customary court. Accordingly, it was quashed. And thereafter direction was given.
To approach, if they want to ventilate their
Yes,
grievances,
yes,
they will approach the customary court, necessary customary court, jurisdictional customary court,
jurisdictional.
or the civil court.
Civil court.
Liberty was.
And his case is that none of the parties has approached,
Yes.
but
yes,
the Gauhati on his own issued this parwanas, which have been stayed. Right? Now you are representing the sole respondent,
Sole respondent.
entered appearance.
Yes.
The parties are before this court now.
Yes.
Okay, you wanted me to see 70, page 70.
68,
60.
paragraph 18.
Hope go back to you.
From 17, paragraph 17.
70.
Same.
So this forum said that the High Court had directed the adjudication of the matter before him
Yes.
directly as
Yes.
inter-customer.
In Parwana itself,
Okay, which according to you, that's not correct.
yes.
That was not the
Only liberty was given to both the parties.
approach. But even if you approach, it may not be the inter-customary court directly. Since they belong to different villages or same village.
No,
Same
place.
Then the Gauhati of that village will be the first.
No, my lord.
No, first court has already given the judgment, Lordship.
Okay.
Now it was at the affiliate stage. In fact, liberty to approach the civil court and the appellate forum itself is in fact partially wrong, because as per Arunachal Pradesh Civil Court Act, Lordship, the appeal against the order of first Kabang decision is before the appellate authority.
And the
Yes.
anyway,
Yes.
so you proceed. It has come up today for it has come up in the orders for
Today, Lordship,
showing the appearance.
yes, Lordship. Today, no, Lordship, I have entered already appearance. On previous occasion, the learned.
It's also under order of stay.
Yes.
So according to you, these are the three parwanas have been issued, which have been stayed.
If my lord see page number 88, even I have submitted an application, whether there was any complaint from the respondent. But they said no complaint has been submitted by the respondent.
GB Secretary Umapura, so Inter-Village Territorial Court of Ubu Bango.
Yes. It's 88.
But it has not been received. But you have not received.
Yeah, I mean, I have submitted this application, my lord, but the head Gambura said they have not received any complaint from the respondent.
We
So
can,
without there being any grievances.
if the would you file any from your side? Anything written from your side? No.
Yes, Lordship, I have filed.
You have already filed also.
Yes. Now, Lordship,
So we I think we should call for the records then.
before, may please, if my Lordship may allow, before coming into the merit, of course, the merit will be from the petitioner side. Now, my Lordship has to see who is the respondent here. As I have raised the same issue on last occasion also. The respondent before your Lordship is Gaubura, who is now a civil judge. He has been made as a party, Lordship. My Lordship, see the respondent. Assuming
I see. Oh, that.
if there is any illegalities.
You're representing him.
Yes.
Togamori is the head Gambura.
Head Gambura.
Okay.
And
How the civil judge can be made as a party
That is also true.
in a proceeding? It was the last.
It's the other party actually.
Yes.
I'm aggrieved by a certain process issued from a court. I have to make respondent the party at whose behest
Lords.
the process was issued.
Yes.
Not the court. Really.
Who has the
But
legal
also-
right to protect the interest of that order, Lordship? That has to.
My lord, the issue here is,
Per se, that is the thing.
my lord, the
That
issue
has to
here
be
is the
decided.
respondent have not submitted any complaint. He has no grievances. So without there being any grievances, the Gambura himself on sumoto issuing parwana. More so, my lord, the Gambura and the formal judicial officer, they cannot be equated. Because from the appointment to power, function, duty, exercise of the Gambura is quite unique.
That's true, but
They're
forum-
politically appointed
yeah, that's-
by DC
I
or
appreciate your summation, but the forum head No, in a generic sense,
Lordship.
the head of the forum which has passed the order,
Yes,
and the party is not necessary.
yes, as per now,
Otherwise, we will go on have to
yes, Lordship,
appoint our standing councils
Lordship,
everywhere. Anyway,
yes.
so I think I feel that if both of you agree, we can get because the records need to be seen. Because he has contended.
My lord, if
Records regarding Lordship, the records will be to decide on the merit. But here the party, while the civil judge, since the customary court has been recognized as a civil court, customary court, bless authority. Now, how that can be, they can be made as a party, Lordship.
So we dispose it of at this stage. Over.
In fact, Lordship, if
or we admit it and fix it for hearing, calling the record to check whether indeed any complaint has been filed or whatever he has contended.
my lord, if my learned
Which
senior,
course of action would be better?
my lord, if my learned senior agrees, what I submit is
Yes.
setting aside this parwana and liberty may be given to both the party to approach. Thereafter, if they issue parwana, no problem. But here, without hearing complaint, they are issuing parwana. That's all. And
The
my lord,
order of
one
the
more-
the order of the High Court is at page 64.
60, my lord, it's at page 68,
Let me see.
64 to 68. And the operative is at 68.
now, if today my Lordship is disposing of this petition while making the civil Gauhati as a party in the present form, it will set a precedent, Lordship. Tomorrow, from tomorrow onwards, now the many blazers, they will start.
Oh, no, that cannot be. Should be the High Court order. So what do you propose?
My proposed, Lordship, there should be a necessary party should be made as a party. How the Gauhati cannot.
We can struck him off and he can make the party and the respondent, the other person who's supposed to have made a complaint.
That can be. That in fact they have to withdraw this petition.
Let me see the operative. You just read para 18 of the order. Page 68. No?
Consequently, either party shall be at the liberty to approach the competent civil court under the Arunachal Pradesh Civil Courts Act 2021, amended from time to time, for setting aside or for fresh adjudication of the dispute relating to a plot of land that is Kesarika. Or in alternative, either party may also approach the inter-village territorial customary court or the apex customary court as may be competent under the AFR 1945. So only liberty. No direction to conduct the kava.
That is one aspect of the matter. The other aspect of the matter is what is pointed out by your learned friend. That the structure of the petition is incorrect because you have made the court a party.
My lord.
So that we can always direct that his name is deleted, struck off, and he may implead the private person at whose behest the complaint is supposed to have been filed.
My lord, if my
actually not filed.
My lord, if my learned senior agrees, what I suggest is rather than wasting time, we should set aside an direction.
Yes,
that will be better, Lordship. Right.
But my lord,
subject to
my lord, what my lord,
regarding the implement of the rest.
My lord, in our villages, in our tribal culture, the head Gamburaj and the Gamburaj, they are interestingly relation with the village people. So sometimes they malafidely favor some other party, showing favoritism. That's why I made them as a party, because they are malafidely conducting the kava. If my lord allow me to show how he has conducted this kava since from the beginning, he is keeping the all the judges who were the favor of the respondent. He has removed the judges who were in my favor. Lots of things the head Gambura has conducted. So, and I'm aware that, my lord, the judicial officers shall not be made as a party. However, Gamburas are a bit different. They are, since from the appointment, the power they exercise, they cannot be equated to judicial officers. So this question will, if determined, if my lord is ready to determine.
In that case, Lordship, instead of wasting time, I may be allowed 2 weeks time for filing affidavit, because I have received in terms of this first earlier order of this honorable court, the private party, one of the another party, they have filed a appeal before us. Accordingly, on receipt of their appeal, we have issued this paravana which is under challenge. So in that case, Lordship, I may be allowed 2 weeks time to file.
And in the meantime, should we post this for hearing? Hearing?
Yes, admission hearing, Lordship.
No, hearing only.
Hearing,
Final hearing.
final hearing may,
You won't prefer
yes,
at the stage
it,
of
it may take time, Lordship, because
here it won't be a problem. In principles, sometimes it's a problem. Here it won't be a problem. Here it should not be that much of a problem. At least we can say
Lordship,
that.
Lordship.
But if you do not want that, then I will not force you. We'll keep it at this stage only. Now it's come for orders.
Yes,
Has
order.
it been admitted?
That
No,
is-
not yet admitted. Has it been admitted?
No, not yet admitted.
Then it can be
It was
posted
only
at
on
the
last
stage.
week I have.
It can
entered my
be
first-
it can be kept at the stage of admission.
Yes,
Admission.
yes. In the meantime, I'll file it.
My lord, in that case, I have a phone recording where the head Gambura himself said that no complaint was received. That I may be allowed to produce that. There is a phone record.
You file a short affidavit then, additional affidavit, right? You'll file a short affidavit, bring that on record.
Yes.
It may help to dispose it of, because there's nothing. Then it will become clear that unilaterally,
Yes, yes.
That is why, my lord,
the
yes,
process
Lord.
has been issued.
Yes, Lord.
And his affidavit will, because his affidavit again will make the portion more clear.
I'll show their appeal, Lordship.
Hmm.
That I will bring on record.
Third, so, order dated 5/3/26, the second paragraph of the UK. An earlier round of litigation between the parties with regard to entitlement to ancestral land named Kesarike was an earlier round of litigations relating to so and so led to filing of civil revision before this court, being CRP 70 of 25, which was disposed of by judgment and order dated 26/11/2025. Whereby the decision of the Inter-Village Territorial Customary Court within bracket Bango Level Court, it is at page 68, dated 9/6/25, was set aside. And the parties were given the liberty to approach the competent customary or civil court for throwing more light on the matter. Para 18 of the said order may be reproduced here in below. Page 68. Full stop. The learned counsel for the petitioner contains that the aforesaid order of this court was misinterpreted by the customary authority by issuing the parvanas on his own accord, as no complaint has been filed on behalf of the other party which was before this court in the earlier round of litigation. He seeks permission to file an additional affidavit bringing on record the relevant document first. On the other hand, the learned counsel for the respondent submits that the respondent Toga Mori, who is the head HGB of Moli village, has been incorrectly implemented as the party respondent, as the petitioner has to implead, if any, the other party with whom the dispute had originally arisen. Full stop. It is submitted that the impleadment of the customary authority itself as party respondent is untenable. The learned counsel also seeks some time to file an affidavit, bringing on record certain facts and documents if any. So let it be. So the respective prayers are allowed. List this matter after
2 weeks.
After 2 weeks in the admission column.
In the admission.
Lots of interim may be continued.
By order dated just before that, you read, in the white order dated 5/3/2026 itself, the three parwanas dated 16/12/25, 19/1/26, and 23/2/26 issued by the respondent, sole respondent, who stayed. The said interim orders will continue till the next date of listing as well. We'll stop. List the matter after 2 weeks.
Briefly obliged.
Sort it out. Next time, next date, you sort it out.
Item number 22.
Yes. Oh, yesterday's matter.
Yes, madam.
Could you locate any judgments?
Yes. Prior to that, if your lordship just come to 127 km. 144, your lordship.
Just a minute. All right.
Your lordship, didn't submit finish it. कर देना.
I'll come to you first.
Yes.
Page.
Your lordship may take BNSS, your lordship. I'll just come to it.
BNSS.
Lordship may come to section 144, your lordship.
144.
Yes. Your lordship, 144 is the corresponding respondent to 125 of the CRPC. Your lordship is well aware that this is where the maintenance was sought for, your lordship. After the order of 10,000 was given for the maintenance of the child, your lordship, the revisionist herein had come before the learned trial code under 146, your lordship will see. 146, your lordship.
Earlier 127.
Yes. 146, your lordship will see there is only one point for an enhancement. Prayer for enhancement is the proof of change in circumstances. Now, if I may deal with the circumstances, your lordship. The circumstances put before the court was that the payment of the father was enhanced, your lordship, and also the difficulties faced by because the child was going to a school having a admission fee of certain amounts which could not be afforded by the mother, your lordship. Now, with regard to the revision, I'm just placing my judgment of our own High Court, your lordship.
Don't go into full merits because we are only deciding the question of stay.
Only on that.
Otherwise, we
if
might
the
as well
revision-
dispose it of.
If the revision court can enhance, your lordship. If I may take your lordship to paragraph 4 of the judgment, your lordship. I'll just read the gist of the merit of that case, your lordship. The fact of the case is that the respondent wife initiated a proceeding under section 125 of CRPC against the petitioner claiming monthly maintenance of ₹2,000 for herself and her two sons, children on the ground that the second party subjected her to torture, both physical and mentally, even when she was pregnant carrying the second child in her womb and was driven out of his house. But thereafter, she was taken back on a settlement between the parties and she stayed there for some time with petitioner and then she was again subjected to torture, resulting her leaving the matrimonial home again. The respondent wife claimed the income of petitioner to be ₹5,000 per month as a driver. The petitioner as second party in the aforesaid proceeding filed his written statement and contested the proceeding, denying the allegation manner. I peruse the judgment of the learned trial court as well of the learned revisional court. It deserves mentioning here that although the maintenance was claimed for the respondent wife and hers, yet the learned court below granted maintenance allowance only to the wife in view of the fact that her children are being maintained by the petitioner, keeping them with them. On perusal of the judgment of the learned trial court and evidence available in the record, it appears that the respondent wife is the legally wedded wife of petitioner which fact is not disputed. There is also no dispute that the petitioner father is the two children from the respondent wife. The learned court below, after examining the evidence of the respondent wife side as petitioner, also the evidence led by the petitioner of opposite party in the proceeding under 125 of the CRPC, and on hearing both the side, passed the impugned judgment granting maintenance allowance of 500 to the respondent wife to be paid by the petitioner monthly. Again, this judgment of the learned trial court, therefore said criminal revision was filed before the learned session judge, challenging the legality, propriety, and the correctness of the said judgment and order. The learned session judge, however, not only affirmed the decision rendered by the trial court in the judgment and order dated so-and-so in respect of entitlement of wife responded, but even went on step further to enhance the monthly maintenance allowance from 500 to 1,000.
Just pause for a moment. Just
yes.
pause for a moment. Okay.
Now, the ninth is the question that the court was dealing with, Your Lordship. The first question, therefore, is whether the learned revisional court is entitled under the law to enhance the maintenance allowance, particularly when there is no revision preferred by the respondent wife to enhance the maintenance allowance, Your Lordship.
Okay.
So the only fact different in this matter was that under 125, certain amount was given for an
500 was given. That was challenged. And
for enhancement.
That was enhancement. It was challenged.
Yes, it was only challenged. 127 was not filed, Your Lordship. Now, during that challenge, the maintenance that was sought for was enhanced by the revisional court, Your Lordship, without filing of 127 or amendment of the prayer made under 125, Your Lordship. Now,
but enhance it further.
Enhance, Your Lordship, under the revision provision, Your Lordship. Now, if I may take, Your Lordship, to paragraph 10, Your Lordship. 10 and 11 are the paragraphs that I'm relying upon, Your Lordship. The learned amicus curiae, Mr. Datta, has referred to a decision of the Honorable Supreme Court in Savita Ben Somabhai Bhatia versus State of Gujarat and others, reported in so-and-so, as well as the decision of the Honorable Andhra Pradesh High Court in the case of S. Brahmamandam versus Ramadevi and others, reported in 2007, Criminal LJ 811, and submitted that the enhancement of the maintenance allowance by the learned session judge is within his judicial power. This submission has been made as against the submission made by the learned counsel for the petitioner that in the absence of any application for enhancement or in the absence of any challenge to the amount of maintenance allowance before the learned session judge by way of a revision petition by the respondent wife, no order enhancing the maintenance allowance from 500 to 1,000 per month could have been passed. On hearing the learned counsel on this point as canvassed before this court, I have examined the judgment of the Honorable Supreme Court in Savita Ben. In that case, the facts reveal that the petition claimed the maintenance was made within, while there was a limitation of maintenance allowance up to 500 only, and at that time, the Honorable Supreme Court passed the judgment. The limitation was deleted from the provision of 125 of CRPC. So at the time of passing of the judgment by the Honorable Supreme Court, the limitation of the maintenance was not there in the provision of section 125 of the CRPC. The Honorable Court enhanced the maintenance allowance even in the absence of an application for enhancement. Now at paragraph number 2, the reliance was placed upon the case of Andhra Pradesh, Your Lordship. At next page, Your Lordship, paragraph 20. Firstly, it has to be seen whether the learned session judge has power to award more than the amount claimed in the application towards maintenance. The Apex Court very recently in Savita Ben Somabhai Bhatia versus State of Gujarat and others held that in application filed under section 125, at time when maximum limit of maintenance was prescribed, the request for enhancement over and above the maximum amount fixed under Section 125 prior to the amendment can be considered, and that plea that the original application has not been amended is too technical to be raised in view of the fact that Section 127 CRPC permits increase in quantum. A similar contention as raised in this case was raised before the so-and-so. Now, even in this.
Okay.
Now, even in this, the revisional, the enhancement made by the revisional court, Your Lordship, even without filing of the application under 127 was considered, Your Lordship. And both the judgments relied upon was taken into consideration by the court, Your Lordship. Your Lordship will find at page number 14, Your Lordship. Paragraph number 14, Your Lordship.
Just a minute. Yes, read it.
Yes. From the para 19 and 20, it appears that the Honorable Andhra Pradesh High Court held that it is within the ambit of the power of the learned session judge to enhance the maintenance allowance. Therefore, although the judgment of Honorable Andhra Pradesh High Court is not binding upon this court yet, it has persuasive value. I am persuaded to agree with the judgment of the Honorable Andhra Pradesh High Court in view of the nearly similar facts in the present case which was dealt with the judgment of the Honorable Andhra Pradesh High Court. Therefore, the enhancement is held to be correctly ordered, Your Lordship. However, as far as the quantum of enhancement is concerned, this issue as raised by the learned counsel for the petitioner shall be taken up slightly later, Your Lordship.
So according to this law, as per your submission,
Yes. Now,
can.
yes,
Sessions Court can.
Sessions Court can. Now, if I the reason why I have taken Your Lordship to 144 and 146 is that once maintenance is claimed under 144, Your Lordship, all the documents are being produced and that is to be under consideration, Your Lordship. Now, looking into those documents and evidences, Your Lordship, a court grants certain amount for maintenance, Your Lordship. Now, since the trial court still after the passing of the final order is still a factus officio, Your Lordship, I mean, enhancement under 127 is completely different, Your Lordship. It needs change of circumstances and the party has to prove that certain circumstances has changed and therefore we are praying for the enhancement of whatever is given under 125, Your Lordship. Now, for example, Your Lordship, if the trial court enhances it by himself under 127, Your Lordship, and if the parties are aggrieved, if the party who has been ordered to give the enhanced amount, Your Lordship, they'll go before the revisional court here. Now, the power of the revisional court is either to decrease the amount, looking into the evidence given under 127, Your Lordship, for enhancement, either decrease the amount or increase the amount. Considering only the evidences that was produced to prove that there was a change of circumstances, Your Lordship. If I may also produce certain.
In our case, the wife sought enhancement.
Yes, under 120.
Which was refused.
Which was refused.
She took up the matter to the Sessions Court.
Court.
Agreed that it should have been
yes.
It should have been announced.
Yes, if I may take, Your Lordship, I'll just show the prayer part, Your Lordship. You will see the
Sessions Court interfered with the order and made the enhancement himself.
Himself, Your Lordship. Now, if I may take, Your Lordship, to the they have only annexed the impugned judgments, Your Lordship. I have the entire miss case, the file of the miss case. Miss case was filed before the revision was filed before the Honorable Court under application under 397, Your Lordship. And the prayer made in therein was for the quashing of the order passed by the trial court, dismissing the claim of the the wife, and also for granting of enhancing the amount from 10,000 to 30,000, Your Lordship. Now, if these prayers were not made before, specific amount of that enhancement was not made before the trial court under 127, that would have been a different case that we have not prayed for and the court could not interfere with, Your Lordship. But we made a specific prayer.
Prayer was made, it was refused.
It was refused. The petition was
And the session judge was adjudicating the correctness or otherwise of that refusal.
Refusal, and more particularly.
And in doing so, he allowed the enhancement.
Enhancement, Your Lordship. Now the thing is that while discussing the legality and the legality of the order passed by the trial court while dismissing, Your Lordship, the court has very clearly interpreted that which change of circumstances that was brought before the trial court was not entertained by the was not taken into consideration by the trial court, Your Lordship. And that's where the order was passed, Your Lordship. If I'll just take, Your Lordship, to certain judgments of our own court, Your Lordship. There's a small judgment, a very small judgment, Your Lordship. I'll just show under 127 how could the court interfere with, Your Lordship. The second page, there's no paragraph as such, but the second paragraph, Your Lordship.
Second para?
Second para, Your Lordship. It appears that initially the present respondent wife had approached the learned magistrate under 125 CRPC seeking maintenance for herself and her child. An amount of rupees 2,500 for the wife and 1,000 for the child respectively was granted. Subsequently, the respondent wife once again approached the magistrate under section 127 CPC for enhancement of the maintenance amount, and the learned SDJ M. Balaji's Pathshala, upon appreciating the fact that since 9 years has elapsed from the date when the maintenance was last granted, there was definitely been a change of circumstances, and accordingly deemed it pertinent, fit to grant maintenance of rupees 3,000 for wife and rupees 3,000 for the child, totaling to 6,000. The petitioner herein challenged the aforesaid order by way of criminal revision before the learned session judge Balaji, and by order dated 2/7/25, the petitioner was partly allowed by reducing the maintenance amount to rupees 3,000 for the wife and 2,000 for the child, totaling to 5,000. On perusal of the impugned judgment, it appears that by way of the impugned order of the session judge, partial relief was granted to the petitioner by reducing the total maintenance amount by rupees so and so. However, not being satisfied by that, the petitioner has filed the instant criminal petition challenging the grant of even the reduced amount of maintenance, which in any view of the matter cannot be regarded as excessive for the purpose of maintaining a woman and her child. My only reason to submit this judgment is that the revisional court, after consideration in the by the trial court under 127, has the power to take into consideration the change of circumstances that was missed out by the trial court, and either can enhance or reduce the amount, Your Lordship.
Okay.
This is also, Your Lordship, I won't be this
One more decision.
Yes, I'll just place, this is just looking into the change of circumstances that was decided, Your Lordship, nothing is said. So my contention is that, Your Lordship, 125, while dealing under 125 is a different. Your Lordship, recently, even the Allahabad High Court has clearly stated that once you are granted maintenance under 125, Your Lordship, you cannot directly go to the High Court under 401 for enhancement of the maintenance amount, Your Lordship. Prior to going to the High Court under 401, Your Lordship, you have to file 127 before the appropriate trial court, Your Lordship, who has passed the order for maintenance. Thereafter, if any order is given under 127, then you can come before the revisional court, Your Lordship. Now, while revisional court, while deciding the matter, has to see that what kind of change of circumstances was made proved by the parties and what the trial court did not consider, Your Lordship. So as per my submission, Your Lordship, the revisional court can have the power to enhance
it.
Yes.
When the order is challenged.
Yes.
This judgment is
This the judgment by our own High Court, Your Lordship, this judgment only deals with what are the change of circumstances, because 127, that is 146 only requires the change of circumstances for enhancement.
All right. Yeah, please.
If I may, my lord, I have submitted, my lord have asked, inquired regarding payment, firstly, my lord, regarding the payment. I have submitted,
हमको भी देता है यार एक copy.
we could only obtain this, this short notice, my lord. But the account statement reflects from 2000, January of 2022 till December of 2025.
Regarding the 10,000 payment.
And according to the entries made, if I have not missed, my lord, 40 payments have been made in between 3rd January 2022 till October 2025. So the maintenance amount was
Between?
3rd January 2022
15.
to October 2025.
Sorry, please say the dates again.
From 3rd January 2022
T122 to
till October 2025.
October 2025. 40 payments.
40 payments, monthly payments. I could see, my lord, that 40 payments. So there are 45 months and 40 months have been paid, my lord. So in between, if something
Missed.
is missed,
40 for 40 months.
for in total from January till October, there will be 45 months, my lord.
Months, but 40 months payment have been made.
For 40 months payments have been made, my lord. I have marked, my lord, those, highlighted those payments. If I may, my lord, now.
For the okay, so and you quickly go through your decisions. Two judgments you are citing.
Yes, my lord. My decisions are very only 3 pages, my lord. Oh, I'm only relying on one paragraph each from both the judgments. Now, my lord, the issue that I am aggrieved with is that, my lord, the revisional code, my lord, it can, as my lord has stated, my lord, it can examine the legality or correctness of the decision, my lord, that is given. But that exercise has to be undertaken under certain parameters, my lord. Our grievance is that the learned revision code has exceeded those parameters. Therefore, it has acted beyond jurisdiction, my lord. If my lord will have Bakulal Bai, my lord, the judgment Bakulal Bai versus Gangaram. And if my lord will kindly come to page number 540, para 7, my lord. If I may read, my lord, there are 5 lines, my lord. If I may read, my lord.
Citation bola na. Citation. Yeah.
My lord, if I may read. The other findings of the magistrate on the disputed question of fact were recorded after a full consideration of the evidence and should have been left undisturbed in revision. No error of law appears to have been discovered in his judgment, and so the revisional courts were not justified in making a reassessment of the evidence and substitute their own views for those of the magistrate. This is our first point. Factual point, my lord, reappreciation of the evidence to substitute one's view is not permissible while exercising revisional jurisdiction, my lord. The second judgment, if my lord will have Uttoma versus Muhammad, my lord.
Okay.
Paragraph 6, my lord, page number 587, my lord. Now, basically, my lord, both these cases were dealing with maintenance cases, revision, then before the Honorable Apex Court, my lord. Paragraph 6 herein also, my lord. The question whether appellant 1 was the married wife of the respondent and whether appellant 2 was the legitimate or illegitimate child of the respondent are preeminently questions of fact. The learned magistrate, after considering the evidence as adduced by the parties, held that appellant 1 was not the wife of the respondent. He further held, on the basis of the evidence on record, that appellant number 2 was the illegitimate child of the respondent. We are afraid the learned judge of the High Court committed an error in making a reassessment of the judgment and coming to a finding that appellant 2 was not the illegitimate child of the respondent.
But this judgment of from Gujarat, which you have submitted, Ms. Jini,
Yes, Your Lord.
that the Supreme Court judgment,
Yes, Your Lord.
no, which is discussed in our judgment, our High Court judgment,
Yes.
that seems to take a different view from what is being pointed out. This is the general revisional principle,
General
right?
revision.
That you do not reappreciate evidence,
Yes,
right? We know that.
Yes.
But in the context of maintenance and its enhancement, this judgment which is discussed in the High Court, our High Court judgment,
Yes, Your Lord.
no, not the Gujarat High Court judgment,
Yes.
the Supreme Court one.
Yes, yes.
That seems to take a different view.
With regard to the Supreme Court judgment, the one I placed, Your Lordship, and the reference was made in Your Lordship, this,
Then we have to see the quorum of this.
no, the Savita Ben judgment, Your Lordship, that has been
I'll
reflected.
come to you, just a minute.
Sorry.
This,
At page number.
Sabita Ben.
Savita Ben, Your Lordship. Lordship will see mainly in this Savita Ben case, the issue was if the wife, the definition of wife, can a person who is in a living relationship be defined as a wife, Your Lordship? That was subsequently discussed in another case also taken into consideration, the Savita Ben case, Your Lordship. And also, Your Lordship will see my learned friend that, therefore, I had already submitted, Your Lordship. 125 and 127 has to be looked into different aspect, Your Lordship. My learned friend who has submitted the judgment, Your Lordship, more particularly deals with 125.
This is anyway, this is actually a determination of fact based on evidence regarding status, that whether he was legitimate son or illegitimate son.
Also, status.
The maintenance is more of a summary procedure.
Yes.
Actually, right? So anyway, so any finding of any proper finding of fact based on evidence cannot be reappreciated in revision.
Yes, ma'am.
That's clear.
Yes.
Why I'm relying on these two judgments are because these judgments have arisen out of a 125 proceeding only, my lord. Both the Supreme Court judgments, my lord.
That's anyway, these two, then another one.
And my lord, the other one is a general principle regarding the revision, my lord.
Kishan Rao.
Kishan Rao, my lord. If my lord would kindly have page number 169,
Para 12. Para 12.
Because, my lord, the two judgments that I placed regarding maintenance, my lord, the reason for placing them is that even in maintenance proceeding, my lord, the revisional standard that is exercised by the revisional code is the same, my lord, as in any other revisional jurisdiction, my lord. May I read, my lord? There are 12, my lord. This court has time and again examined the scope of section 397, 401 CRPC and a ground for exercising the revisional jurisdiction by the High Court. Instead of so and so, while considering the scope of the revisional jurisdiction of the High Court, this court has laid down the following. In its revisional jurisdiction, the High Court can call for and examine the record of any proceeding for the purpose of satisfying itself as to the correctness, legality, and propriety of any finding, sentence, or order. In other words, the jurisdiction of one supervisory jurisdiction exercised by the High Court for correcting miscarriage of justice, but the said revisional power cannot be equated with the power of an appellate court, nor can it be treated even as a second appellate jurisdiction. Ordinarily, therefore, it would not be appropriate for the High Court to reappreciate the evidence and come to its own conclusion on the same when the evidence has already been appreciated by the magistrate as well as the session judge in appeal. Unless a glaring feature is brought to the notice of the High Court, which is otherwise tantamount to gross miscarriage of justice, or scrutinizing the impugned judgment of the High Court from the aforementioned standpoint, we have no hesitation to come to the conclusion that the High Court exceeded its jurisdiction in interfering with the conviction of the respondent by reappreciating the oral evidence. My lord,
According to you, what would have been the correct course of action for the revisional courts to, if it disagrees with the finding of the magistrate, that enhancement prayer should not have been dismissed, to revert it back, to send it back for fresh determination.
Yes, my lord.
Because I mean, going by the theory
Yes, my lord.
that the revisional court cannot substitute its own view.
Yes, my lord.
So, but the revisional court, it cannot substitute, except that
Certain.
for argument's sake, that the revisional court cannot substitute its own view.
Yes, my lord.
But at the same time, the revisional court finds in the revision that the refusal to grant the enhancement was not justified. Then what it has to do? Send back,
My lord,
return back
if in my
for fresh
if
determination.
my understanding, my lord, if the refusal was due to non-consideration of some material evidence or materials, my lord, then the proper forum would have been the trial court, which would have examined those
To
evidence,
remand it back. That's
to remand it back to examine those evidence. So
instead of substituting its
Its own.
view. An appellate court could.
even appellate court can.
But it seems to be, these are actually spanning a long period. When this decision came,
Yes.
this was much later.
Yes.
And this decision came earlier, this
Yes.
decision. The first one, which is and so this time gap also sometimes, that we have to see the quorum. If it's three judge, there is no problem. But most probably it is only two judges, so the quorum would be same.
Yes.
In that case, we have to see whether there is indeed some conflict or it turns on its facts. That we have to see. Anyway, we need not go so much into this. So I feel that there's one course of action we can consider is that the judgment we can stay the judgment and he will pay 15,000. Is that
I would not disagree with your lordship, but
somewhere in
with-
between?
with regard to the record that has been produced, your lordship, I'll just want to make a submission on.
Because otherwise, all these, because if we go too much detail into this
Yes, yes.
revisional, that has to be decided at the stage of disposal of the full revision.
Yes. Your
Whether
lordship,
30,000 was justified
Yes.
on the part of the sessions court.
I totally agree with your lordship. Your lordship, just submission to this, the document submitted by them, your lordship. Your lordship will see that they have, as per their own statement, the submission they have made is on that they started to pay from January 2022. Your lordship will see when the judgment was,
My lord,
when the,
that is, I believe I have not been able to submit
Yes, yes.
properly. I have submitted a bank document from 2020 because we could not procure from before, my lord. It's not that we are not paid. We have paid from before. also, my lord.
I'm just coming to that only, your lordship. 2022, your lordship, to 2025, the statement has already, is only being shown, your lordship. The statement nowhere shows the amount to be debited to the account of the respondent, your lordship. My other prayer is that, your lordship, this is an statement shown only from 2023 to 2025, whereas the 10,000 prior to that, your lordship, as I have already submitted, there is no record of transfer to the account of the respondent, neither only the detail is given as withdrawal, transfer, INB, maintenance. There is no account number reflected. It's a withdrawal made by the petitioner himself. And only the gist, when we deposit an amount, we write certain, if your lordship will see the first one, INB, maintenance, your lordship, withdrawal, transfer. So it has been given to which account? All these statements I have just checked, your lordship. It does not shows my account. The other part of
Yes, fairly submitted, indicative. It's
yes.
indicative.
The other part is that why the DDO office was directed to deposit the account from the salary of the complainant, the petitioner herein is because the reason that he was not giving the 10,000. Therefore, if it was directly automatically deducted from,
if there is a DDO of a person, that is the best way.
Yes.
In a way.
So
if it's good for the person also. He doesn't have to bother about paying.
Absolutely,
It will be deducted. And
at least when the
if
admission,
the amount is if the amount is, the dispute with regard to the amount ends and the person is working somewhere having a DDO, that is a good mode. Not bad.
in fact, that would not be a hurdle for him as well as for us, your lordship. We also would not be keeping on harpering him about the maintenance on, reminding him of maintenance on every occasion, your lordship.
My lord, if I may, my lord, my only consider would be, my lord, if after adjudication, my lord, the final adjudication, if it is deemed that we have not been able to make out a case, then only we are praying that the direction to the DDO may be made, my lord, for deduction. Till pendency of will, because my lord, if
Arrears have, like I have already not paid, and
my lord,
they have admitted to the same before, even in the judgment of the trial court as well as of the revision court. It's there, your lordship, their admission, on their own admission also. And a school also from class 6, from nursery to till he's a class 10 student now, Your Lordship. Only 35,000 when he was studying in class 6 at Darjeeling School, Your Lordship. It was only paid, Your Lordship.
My lord, regarding the areas, my lord, we have now they are disputing, we are saying we are paying, they are saying they are disputing, my lord. If it would have been better if they had filed an enforcement petition for this, then everything would have been clear, my
That
lord.
is reflected in the court of the both the courts, Your Lordship, order.
I won't write much, you know,
Yes.
and just
On
sorry.
with regard to Your Lordship, I concede with Your Lordship, if 15,000 is also being given as an
But
continuation of
should it be a direction to DDO or you
DDO,
prefer
Your
that?
Lordship,
My lord,
DDO,
You
Lordship.
don't prefer that.
My lord, if we don't comply with the order, they can always come before this
Because-
honorable saying that we have not complied, then the order may be passed.
No, Your Lordship.
But if at the first instance, my lord, if we have been complying, my lord, kindly we may be allowed to pay it by on our own, my lord.
Your Lordship, I'll just point out this point that they are agreed with the enhancement of 30,000, Your Lordship. They're not agreed with that the transfer directly from DDO, Your Lordship. Then now also they'll be agreeing to 15,000, Your Lordship. What is the issue with directly deduction from with the directing the DDO to directly deduct it from their account, Your Lordship?
My lord, if the money,
Our-
that is the main concern,
our-
whether it comes from
our
the
reason
DDO
for
or
enhance-
our part, my lord.
Our reason for
They should not
enhance
have an objection.
our reason for enhancement was solely that he started ignoring not paying for the school fees, Your Lordship.
But at the final adjudication, the court, this court is now, this matter has come up not as a revision, as a criminal petition.
Petition,
So inherent powers are also there. So we have wider flexibility
Yes.
at the time of final adjudication. But anyway, you reserve this, all this for dispose of this.
Your Lordship, also, Your Lordship, though we are agreeing to 15,000, Your Lordship, my only submission with regard to the placement of their judgment is with regard to 125, Your Lordship. The court while dealing with 127 has not taken the evidence placed under 125. It was a long gone case. 127, the revision court has only.
Just take the short. Mr. Tasu. And Tasu, learned counsel for the petitioner, and PG, learned counsel for the respondent number 1 and her minus son. Good stop. It's already written. Just my last order. You pick my last order. Para 1 of order dated 29/1/2026. You can take it. Then you come to the last order passed by me. Para 2 of the last order, 4/8, yesterday's order. Para 2, 3, and 4. Stop. Next paragraph. Taking his argument forward today, the learned counsel for the petitioner has placed before the court a set of bank statements and contains on the basis of the same that the said bank statements for the period from for the period from 3/1/2022 till October 2025, spanning 45 months, indicate payment of rupees 10,000 for 40 months. Stop. The Further, the learned counsel referring to the, sit down please, have a seat, to the decision of Bokula Bhai, you write from here, so is a citation, and Pathumma, 1986, 585 on his 537 page number, submits that it has been held in those decisions by the Honorable Supreme Court that no, you just write like this. The learned counsel referring to the decision so and so reiterates his earlier contention that the court exercising revisional powers has to just examine the order, the impugn order, to see whether it is perverse or whether it suffers from any jurisdictional error by way of exceeding jurisdiction or not exercising jurisdiction vested in it. Full stop. The court has to see as to whether the impugn order has been passed by overlooking some relevant evidence. It is submitted that in terms of the law laid down, the revisional court cannot reappreciate evidence and substitute its own opinion. We'll stop. Next paragraph. On the other hand, Ms. Jeannie, learned counsel for the respondents, relying upon a decision relying upon a decision of this court in MD Nurul Ali versus State of Assam and others, 2019, within bracket 2019, bracket after bracket 8 GLR 61, refers to paragraph 9, 10, 11 thereof. Full stop. In the said decision, this court had referred to judgment of the Honorable Supreme Court in the case of Sabita Behan Somabhai Bhatia versus State of Gujarat and others, reported in 2005, 3 SSC 636. It is in para 10, you can just cross check it once. It is submitted by the learned counsel by referring to this decision of the Honorable Apex Court that the revisional court adjudicating a petition regarding maintenance or its enhancement has the power to enhance the maintenance on its own as well. Nothing beyond that. It's much only. This court cannot lose sight of the fact that that it is only the aspect of only the prayer for stay has been adjudicated at this stage, and therefore this court would not like to go into more details as the same can be done so at the stage of final disposal. Nevertheless, upon perusing the materials and giving my anxious consideration to the matter, it is directed that the impugn order dated, what is the impugn order?
18/12/2025.
Check on the cost title. 18/12/2025, passed by the learned session judge West Siang Alo in criminal revision 2 of 2025. Shall remain state, subject to the condition that the petitioner shall pay a monthly maintenance of rupees 15,000 per month to the respondent number 1 for the upkeep of the child of the parties, the minor son of the parties. Full stop. Now, the,
Small prayer, Your Lordship.
they shall also clear the areas of 10,000.
Yes, and also, Your Lordship, that is only enhancement of 10,000 rupees. Another was that his admission, the school the school fees also shall be borne by.
That was, okay.
That was no challenge, Your Lordship. Only the enhancement of 10,000 to 30,000 was challenge.
At this stage, it is pointed out by the learned counsel for the respondent that the petitioner had only challenged the enhancement of the amount to rupees 30,000, and that the direction regarding bearing the school expenses of the son of the parties was not put to challenge. Full stop. It is also submitted that some areas with regard to the maintenance amount of rupees 10,000 per month are also pending. In the context of the same, the petitioner shall clear the arrears amount vis-a-vis the earlier maintenance order of rupees 10,000 per month as expeditiously as possible. Full stop. Now, you tell me now, DDO or you will receive?
We will pay ourselves.
My problem is, Your Lordship, I am the second wife, Your Lordship.
Uh-huh.
We hardly meet, Your Lordship. Now, therefore, I have also pointed out that this withdrawal has been made by him, Your Lordship. We have been calling him on many occasions. Sometimes he will be coming and giving. We are not meeting every day. Your
The
Lordship.
bank account.
So the
can be directed at the bank account directly in the bank account of the.
Yes, directly to my account. I don't have any issue.
We can pay
He
directly.
wants to pay directly into your account.
Yes,
That
that
can be
would
done.
also be sufficient, Your Lordship.
Upon mutual consent of the learned counsels on both the sides, it is directed that the respondent number 1 shall furnish the her bank account details. Where you do submit before the trial court, before the registry here.
Before the registry here, Your Lordship.
Okay, you will submit the bank details. Before submit her bank details and particulars of the account before the registry of this court in which she would like to receive the maintenance amount, and the petitioner shall do the needful for depositing the monthly the amount of rupees 15,000 per month into that account.
As well as the arrear amount, Your Lordship.
He'll pay that I have already mentioned.
Yes.
You see, there's a judgment in all for direct transfer. It has been encouraged. Now MACT also we have direct transfer. Honey Goel. There's a judgment called Honey Goel. So it has been encouraged to follow this principle in other cases also, in maintenance also, account transfer.
Yes.
Okay.
That would be.
DDO is an alternative mode, but account transfer is not banned otherwise also.
Your Lordship has
So the
criminal revision 2 of 2024, Your Lordship.
Yes.
Your Lordship has dictated for 2024 it is.
Oh, sorry. Revision order is 18/12/2025. I said 25.
Yes.
Okay, sorry. Thank you for pointing out. Criminal revision 2 of 2024.
Meanwhile, Your Lordship,
After such deposit, the petitioner, no, it will be directly coming into your account. No problem. And then does he need to submit any compliance of the deposit? Not necessary.
If it's directly come to our account, we'll have the record of it also, Your Lordship.
No problem.
Your Lordship, with regard to.
You can always submit for your own benefit.
Yes.
Some compliance, you can keep a record of it. Nowadays, any electronic transaction has a record. You keep a record. Keep one copy, give it to her, and keep one copy for yourself. You can submit it later before the court.
Your Lordship may further give me 3 weeks time to file my reply to this petition. Your Lordship.
The main petition. Next paragraph. The learned counsel for the respondent side seeks 2 weeks time. 3 weeks time.
3 weeks.
3 weeks time to file her counter affidavit with regard to the adjudication of the main revision petition. The prayer is allowed. We need to call for the records also.
Records.
In the meantime, also call for the scan will do, I think.
Scan will do, Your Lordship.
Scan record of the revision as well as the maintenance case. Maintenance case is 4 of 16.
4 of 16.
16, yeah.
4 of 16.
No. Maintenance was already decided. Miss case was filed for enhancement, Your Lordship. Miss case 73 of 2020.
Okay, that would do. That would do. The scan TCR of criminal revision 2 of 24 and the Miss case number
73 of 2022.
73 of 2022.
22.
From the court of the, this will be available in the,
The Miss case will be available before the court of CGM, Alo, Your Lordship, Senior Division, and the
from the respective learned courts below, Session Judge West Siang and CM West Siang. After 3 weeks.
Item number 23.
We'll keep this case clause. It can be discussed. You don't need it now.
No, I have it.
You have a requisite. But
Item
this,
number 23,
this appears to be a bit of a conflict. It needs to be studied.
Yes, yes.
You know,
In fact,
the classic revisional powers, he's right. The revisional powers are supervisory. You know, you do not substitute your own opinion. But in the context of maintenance and family law matters, this seems to be taking a different view.
Yes.
The Savita Ben, I have to see that again.
Yes.
Full judgment.
Yes.
May I please, Your Lordship? Lordship, item number
Yes.
23, my lord. Service is already completed, my lord. Respondent appeared by filing Ukalwatnama, my lord. Lordship, I prayed, my lord, list this matter in admission column, my lord, and also I prayed for interim, my lord, as because the respondent is already appeared, my lord.
Yeah.
Just a minute. So the petitioner is aggrieved by being arrayed as a defendant number 2,
1 year.
defendant number 1 in the money suit, right? The money suit is pending before
CGM, Alo.
CM Malo. West Siang. You are representing, madam, both the respondents?
Yes, I'm representing both the respondents
Both respondents, okay.
and seeking some time to file our objection in their interim prayer. Lordship.
Just senior division allowed, West Siam. Money suit is
Pardon?
pending before the civil judge senior division West Siang, my lord.
Oh, okay. How much time would you like to have?
2 weeks time. Lordship.
Heard, Mr.
HL
Your
Oscar,
good
my
name,
lord.
please?
HL Oscar, my lord.
Oscar. HL Oscar Learned Counsel was appearing through the online mode. You are appearing from
From Gauhati, my lord.
Gauhati. Full stop. Pursuant to issuance of notice, both the respondents have entered appearance through Learned Counsel.
Tirimi.
Full stop. Who seeks 2 weeks time
Yes, sir.
to file an objection on affidavit.
Yes.
On the interim prayer or on the main petition.
In both your their interim also.
Who seeks 2 weeks time to file written objection on affidavit on the main revision as well as on the prayer for stay made by the petition. You file it.
Yes, sir.
Prayer is allowed, list after 2 weeks. Okay.
And date may be fixed, my lord.
Yeah, you want a date to be fixed?
Yes,
Okay,
my
we
lord.
can fix a date also. Why not? Today is 5th, right? 19th August? Exactly
Most
2
of
weeks.
Most
Okay.
of like. Item number 25.
My lord, CD was called for, but we have not received yet, my lord.
Quashing.
Yeah, it's for settlement, basing on the settlement. my lord.
69 and what was which section?
Yes, my lord, it's earlier, my lord, it was false promise of marriage, my lord.
Oh, that one.
Yes, now the
69 is a new section.
new section, right? Newly inserted
And
section, not
350
amounting to rape, my lord.
And 351 was?
Criminal intimidation.
Oh. So get the case diary then.
Yes.
The learned additional PP, Mr. Ate, submits that he could not procure the case diary today and seek some time. Prayer is allowed. List the matter after a week.
Yes, man. After a week, man.
After a week.
Yes.
You want a date? Date to be fixed.
No, my lord.
That's okay.
Obliged, man.
Item number 26 and 27.
My lord, I filed an IA for conversion of RSA into CRP.
Yes, sir, please.
My lord, I filed this IA 155 for conversion of RSA into CRP.
Your Lordship, I'm on behalf of B. Soki, Your Lordship. We'll be filing our objection to that IA, Your Lordship.
Is it permissible in law?
Your Lordship,
The scope of 151 is very wide.
yes, it is, Your Lordship, but then there is an issue because on the earlier occasion, they have filed a revision and they have withdrawn it without liberty, Your Lordship.
I see.
Now they were in appeal, Your Lordship, and the objection was placed that since second appeal, there is no second appeal as per the Civil Court Act, Your Lordship. They cannot come before this as in second appeal, Your Lordship. That's when they are filing this IA for conversion, Your Lordship. We have objection.
No, no, what do you say? Second appeal is there.
It's not there in the APCC.
Oh,
court.
no, yeah, it's not.
So since it's not there, Your Lordship, they'll have to come before this court for
As a
revision.
revision.
But then the power of revision was already invoked on the earlier occasion and they have withdrawn it without liberty, Your Lordship. The same order is
I
being
see.
challenged.
So there are some issues involved.
Sorry, Your Lordship.
Okay, bring out in writing.
नहीं वही तो वो तो है अपहोल्डिंग हो जाता है
Third, learned counsel for the applicant. It is submitted who submits that the instant interlocutory application has been filed invoking the powers under section 151 of the CPC for conversion of the connected regular second appeal being RSA 5 of 2025 into a civil revision petition within bracket CRP under Article 227 of the Constitution of India. Next paragraph. Ms. T. Jini, learned counsel, appearing for the sole or two respondents.
There are two respondents.
For both the respondents, seek some time to file a written objection on affidavit and further content. Should I record that something?
No, Your Lordship, also my assistant may be recorded as on behalf of this okay, Your Lordship, because the respondents are my parents, Your Lordship. So
Oh, is it?
I don't want to be.
Okay, no, that's better. See, submits on behalf of that's representing who's representing the respondents. And 2 weeks time to file a representation, file a written objection on affidavit. It is further submitted by the learned counsel that earlier the petitioner had invoked the revisional jurisdiction, but the revision was withdrawn without any liberty to file afresh. So it will be helpful for the court.
Yes.
So list the matter after 2 weeks.
3 weeks.
3 weeks, after 3 weeks. Obliged. Nothing, no order needs to be passed on the RSA, right? No?
No, no order.
Okay, so it's come up for the IA. Okay. Should we take the hearing because he is not connected? You can inform me. Is there?
With regard to item number 30, Your Lordship, the council who is being received. I would like
30, actually we have one half done, part third. Part third matter, we have to take that because I have to complete it before I leave, right?
30.
29.
Yes.
Yes, let him complete. Mr. Ate was saying, looking after matter, or you were looking after? You were looking after the matter.
Prior to that, Your Lordship, just item number 30, I just wanted to submit, Your Lordship. Earlier, item number 30 was taken up by my learned additional PP, Your Lordship. He expired in the month of June, Your Lordship. Now the files are being re-endorsed to us, so I need some time to look into the matter.
Sorry to hear. No.
I may be given 2 weeks time.
30 learned additional PP. Some is that due to the unfortunate demise of the public prosecutor was looking after the matter. The file has been newly endorsed to her and she seeks some time to prepare for the hearing. Prayer is allowed. List after
2 weeks, Your Lordship.
2 weeks.
I'm for appellant.
In 30.
Yes.
No problem.
30 is
I think other hearing matters may not happen, so councils can need not wait. I think only this matter will do. Item number 21 only. I think 30, 31 and 32 we may not have time. You can 31. You can. I'll just take a.
Lordship, item number 31 won't be taken up. Maybe listed up before.
Yes, because I don't want to save your time because there won't be time. So list you want after 4 weeks. Is he in jail?
No.
He's not.
Suspension.
Okay, that's good. Could not be taken up due to paucity of time. Article 31. Item 31. List the matter after 4 weeks as prayed for. 32 also?
32.
Also.
Can it be fixed on 24?
24th of this month.
24 of this month.
Okay. List the matter on same paucity of time. List on 24/8.
24.
Done.
You're not kindly mark my item.
Okay. Yes. Yeah.
Correspondent number 2.
Okay. Mr. Stapa on the council for respond number 2.
Great.
So you're free. Mr. Bhattacharjee, are you there?
Item number 29.
I'm there, Lordship.
Yes.
Yesterday, Lordship, I have already read the
Continuity of the matter. I mean, yesterday we had done it, right? So you were reading the IO. Give me the paper.
Yesterday, I have already read the evidences on record, Lordship. Now, Lordship, today I will, as I say, submitted yesterday. Today I shall be relying upon some citation. I have already mailed it to your Lordship. But before we go to the citation, Lordship, I would like to attract your Lordship's attention to a rule, a particular rule. Lordship is well aware of that rule. That is the Narcotic Drugs and Psychotropic Substance Seizure, Storage, Sampling and Disposal Rules 2022. Now, this rule in the definition, Lordship will kindly see 2D magistrate.
Rules.
Rule Narcotic Drugs and Psychotropic Substance Seizure, Storage, Sampling and Disposal Rules 2022. Narcotic drugs and psychotropic substance seizure, storage, sampling and disposal rules 2022.
It should be here in the book, I think, no?
It should be, it is there in the book, Lordship. It is, I don't know.
Sampling.
Lordship is using.
Yes. No, I have. 2000, 2022, right?
Absolutely, Lordship. Now, Lordship may kindly come to the definition part.
261, yes. Two 61. Definitions. Magistrate means judicial magistrate.
Absolutely, Lordship. That is where I am on. Here in our case, there was executive magistrate. So whether executive magistrate as per the NDPS Act can act as a magistrate or not, that Lordship may kindly take a call as per this rule. Now, Lordship may kindly come.
For the purpose of section 50, executive magistrate may do. Usually executive magistrate only comes. But here, this particular, for the sampling, it has to be before a judicial magistrate. Therefore, this has been said that magistrate will mean, this definition is specifically for the sampling rules. Sampling, disposal and all that stories.
Now, Lordship may kindly come to drawing of sample, rule number 10. One sample in duplicate shall be drawn for each package on container fees. That is very clear. Now, Lordship may kindly see rule number 13. Dispatch of the sample for testing. This is very important in our case.
Can you increase, Santosh, can you increase the audio on the other side? Increase the audio. Yes. No. They will also adjust it from this side. Okay. I'm hearing you, but it will be more comfortable. Yes. Yeah. Dispatch of sample for testing. Section 13. Rule 13.
Section 13. The samples, after being certified by the magistrate, shall be sent directly to any one of the jurisdiction laboratories of Central Revenue Control Laboratory, Central Forensic Science Laboratory, or State Forensic Science Laboratory, as the case may be, for chemical analysis without any delay. Here in the case, I have already shown that there is a delay for this 1 year. That is there. Now, these are the rules that should be kindly take a call on it. Now I'm coming to the citations also. May kindly take up. I have already mailed those citations. First, I'm referring to Union of India, Mohanlal and others. Para number 15 and 16.
Okay. The citations are available.
That I have already mailed. Lordship may have a look, Lordship.
It's in the file.
No, Lordship. I have mailed it to your Lordship a few minutes back.
He has mailed. Just take it out once.
With PDF. With PDF. Lordship can have a look into this PDF also directly.
Mail. Take it out, and meanwhile you read. I'll follow. Mohanlal.
Lordship.
Mohanlal. I can find out.
2016 3 Supreme Court cases 379.
Okay.
Then Lordship may kindly come to paragraph number 15. It is regarding 52A. It is manifest from 52A to C that upon seizure of the contraband, the same has to be forwarded either to the officer in charge of the nearest police station or to the officer empowered under section 53, who shall prepare an inventory as stipulated in the state provision and make an application to the magistrate for purpose of certifying the correctness of the inventory, certifying photographs of such drugs or substance taken before the magistrate as true, to draw representative samples in the presence of the magistrate, certifying the correctness of the list of the samples you drawn. In 16, Lordship may kindly have a look. Subsection 3 of section 52A requires that the magistrate shall, as soon as may be, allow the application. This implies that no sooner the seizure is effected and the contraband forwarded to the officer in charge of the police station or the officer empowered, the officer concerned is in law duty bound to approach the magistrate for the purpose mentioned above, including grant of permission to draw representative samples in his presence. which samples will then be enlisted, and the correctness of the list of the samples so drawn certified by the magistrate. In other words, the process of drawing sample has to be in presence and under the supervision of the magistrate, and the entire exercise has to be certified by him to be correct. The Lordship will kindly find this was done as per the paper book, page number 15 on 26/11/2019. And he was arrested
Yes.
he was arrested, Lordship will find on 6/10/2018. That means more than
6/9,
1 year.
2018.
6/10/2018, Lordship.
6/10/2018.
Lordship. More than 1 year. This has been after 1 year. This has been done. So this is, I think, it is fatal in the part of the prosecution, Lordship. Then Lordship may kindly come to another judgment, which I am relying. Arif Khan alias Aga Khan. That is in Supreme Court, Lordship will kindly find. I have mailed it already, Lordship.
Okay, he's taking it out. Arif Khan versus Aga Khan.
Arif Khan alias Aga Khan versus State of Uttarakhand. Uttarakhand.
State of Uttarakhand.
Lordship.
Yes.
Paragraph
Citation.
number. Citation,
Yes.
Lordship. I have citation is, Lordship. It is criminal appeal number 273 of 2007. I have downloaded it from the Honorable Supreme Court, Lordship.
Criminal appeal number
273 of 2007, Lordship.
You kindly give me the date of decision if you,
Yes,
it should be available.
Yes. April 27, 2018.
Okay.
Lordship may kindly come to paragraph number 23, Lordship. Paragraph number 23.
Yes.
Their Lordship have held in Vijay Shin Chandubha Jadeja that the requirement of Section 50 of the NDPS Act are mandatory, and therefore the provision of Section 50 must be strictly complied with. It is held that it is imperative on the part of the police officer to apprise the person intended to be searched of his right under Section 50 to be searched only before a gazetted officer or a magistrate. It is held that it is equally mandatory on the part of the authorized officer to make the suspect aware of the existence of his right to be searched before a gazetted officer or a magistrate if so required by him, and this requires a strict compliance. It is ruled that the suspect persons may or may not choose to exercise the right provided to him under Section 50 of the NDPS Act, but so far as the officer is concerned, an obligation is cast upon him under Section 50 of the NDPS Act to apprise the suspect of his right to be searched before a gazetted officer or a magistrate. This is the judgment which I am relying, Lordship. Then Lordship may kindly come regarding delay in sending the samples to the forensic. Rishi Dev alias Onkar Singh versus State of Delhi. It is the Delhi High Court judgment, Lordship.
Rishi
Dev. RISHI Rishi Dev.
DEV.
DEV, Lordship. Alias Onkar Singh versus State.
Omkar, huh? OM.
ONKAR. Onkar.
Onkar.
Onkar Singh versus State. I have
Delhi
mailed
High
it
Court.
to the Lordship. Delhi High Court, Lordship.
The date of
That is,
decision?
1st May 2008.
All right.
Para number 23, Lordship. This court finds that the prosecution has in this case failed miserably in satisfying the requirement of law. The delay of 3 months in sending the sample for testing the instant case must be held to be fatal to the case of prosecution. Since on the fact of this case, this court is not satisfied that the seized sample are properly preserved during the period of delay and that the sample sent for testing was that was seized. Since the accused is entitled to succeed on this ground, this court is not examining other grounds urged by the accused. So here in our case, Lordship will kindly see there is a delay of more than 1 year in sending the sample.
No, 3 months.
3 months. 3 months in sending the sample. No, in this case 3 months. In our case 1 year.
Certification of 1 year,
Acha.
but FSL was up to 3 months.
In our case also it is 3 months, Lordship.
3 months
Then
delay in sending the sample.
Sending the sample.
Sample was sent on 11/12.
Sample, Lordship, may kindly take a note, Lordship, page number 22 of the paper book. Sample was sent on 11/12/2018.
Page number
22 of the paper
81.
book, Lordship.
22.
22. Paper book.
Got it.
Lordship.
Yes.
Then the next citation I am relying, Lordship, may kindly have a look, Lordship. That is Tirupalli Srinivas. It's a very recent judgment, 2024, Lordship, versus State of Andhra Pradesh. It is decided on, Lordship, 25th March 2025.
Okay, it is Supreme Court decision.
Yes, Lordship, Supreme Court, Lordship. I'm relying upon paragraph number 13, 14, and 15. Lordship, may kindly note the criminal appeal number 1474 of 2025.
Oh, date of decision will do. 1474. 25/3/25. No? Para
Lordship.
13, 14, and para 13, 14, and 15.
Lordship, I'm reading out those paragraphs, Lordship.
Okay, go ahead.
In Bharat Ambale, Supra, this court held that the purport of Section 52A NDPS Act read with Standing Order 1/89 extends beyond mere disposal and destruction of seized contraband and serves as a broader purpose of strengthening the evidentiary framework under the NDPS Act. This decision stresses upon the fact that what is to be seen is whether there has been substantial compliance with the mandate of Section 52A, and if not, prosecution must satisfy the court that such non-compliance does not affect the case against the accused. This is also what is held in Hashif Supra. In the present case, from the evidence on record, it has been seen that it is clear that the seized contraband was not properly sealed. In our case also, the IOS said that it was not sealed, Lordship. Coupled with this is the fact of the seized contraband not being produced before the trial court prior to 3rd July 2010. It is difficult to accept the prosecution case that there may not have been strict compliance of Standing Order of number 1 of 89. The seized contraband was not tampered at all. Keeping of the seized contraband by PW3 in a separate room in his office for 15 days could give rise to an allegation that the seized contraband was by itself substituted and some other items planted to falsely implicate the accused. To avoid suspicion, circumstance, and to ensure fair procedure in respect of such seizure, it is always desirable to follow the Standing Order, which provides suitable guidance for the officers investigating crimes under the NDPS Act. Should there be any departure, the same must be based on justifiable and reasonable grounds. We are satisfied, on appreciation of the evidence on record, that the possibility of tampering during the 15 days period cannot be totally ruled out, and that not only has there been no substantial compliance of the Standing Order, the departure has also not been justified. In paragraph number 15, Lordship, it is written as such, Lordship. We have also found from the material on record that there has been clear non-compliance with the provision contained in Section 52A of the NDPS Act, either possibly due to lack of experience of the investigating officer or his lack of knowledge of relevant provision of the NDPS Act. There were lapses which were duly noted by the session judge. Thus, we are unable to hold that there was primary and reliable evidence before the trial court in respect of the offence committed. The onus of proving that compliance with Section 52A did not affect the case of the prosecution has been the duty discharged by the has not been duly discharged by the prosecution. So prosecution failed there, and in our case also, I submit with all humbleness, the prosecution has failed in our case too. Because Lordship may kindly have a look to the IO statement in page number 55. There it has very clearly said that I have not personally scaled the contraband regarding the application of the correctness and the inventory was made for several cases together. During certification of the correctness of inventory, I have produced the sealed material before magistrate. It is not made by board. Anyway, it is there. I have already read it. Lordship may kindly have a look into page number 55, Lordship. Then Lordship may kindly come to one of the resounding judgments. Bharat Ambale versus State of Chhattisgarh. This is Supreme Court, Lordship. Supreme Court judgment. It is decided, Lordship will kindly find, it is decided on 6th January 2025.
Yeah, after that.
Now, in Siripoli's judgment also, Bharatambe has been referred to. Lordship may
Yes.
kindly come to the parameters that has been laid down. Parameters number 8. Where there has been lapse in the part of the police in either following the procedure laid down in
This is in para.
para number 8, Lordship. It is there. I'm just saying the parameters is in from paragraph number 50. 50.
50.
50.
Parameter H.
Parameter 8.
Okay.
Roman 8, Lordship. Where there has been
Roman
lapse
8.
on the part of the Roman 8. Where there has been lapse on the part of the police in either following the procedure laid down in section 52A of the NDPS Act or the prosecution is in proving the same, it will not be appropriate for the court to resort to the statutory presumption of commission of an offence from the possession of illicit materials under section 54 of the NDPS Act, unless the court is otherwise satisfied as regards the seizure or recovery of such material from the accused person from other material on record. So presumption cannot be automatically gone into. Then parameters number 9, Lordship. The initial burden will lie on the accused for the first lay the foundational fact to show there was non-compliance of section 52A, either by leading evidence of its own or by relying upon the evidence of the prosecution. And the standard required would only be preponderance of probabilities. That we have already shown from the evidence on record that there was total absolute non-compliance, Lordship. Then 10, Lordship may kindly see, this is very important. Once the foundational fact laid indicate non-compliance of section 52A of the NDPS Act, the onus would therefore be on the prosecution to prove by cogent evidence that either there was substantial compliance with the mandate of section 52A of the NDPS Act or to satisfy the court that such non-compliance does not affect its case against the accused and the standard of proof required would be beyond a reasonable doubt. This is in Bharat Ambe, Lordship may kindly take a note, Lordship. Then I'm relying, I have mailed all these judgments to your Lordship. Then I have recently got one judgment, Lordship, it is of our own High Court. Muhammad Manirul Jaman, alias Moni versus State of Assam. Criminal Appeal 392 of 2023. Our own High Court, Lordship. Para number 54.
Monirul Jaman, date of decision.
Manirul Jaman, date of decision, Lordship. Kindly give me 1 minute.
It's
time,
not
Lordship. I'm just
it's not a reported case, right?
Manirul Jaman, no, Lordship, I could not find it out.
Recent decision. Okay.
It is 9924, Lordship.
9924. It might be reported also. Then anyway.
I have
Guwahati
find
High
it
Court.
out from our website, Lordship. Guwahati High Court, Lordship. Lordship may kindly come to paragraph number 54, Lordship. I will mail this to your Lordship. The penal provision of the NDPS Act 1985 prescribes very harsh punishment for the offender. Therefore, it is incumbent for the prosecution side that the mandatory procedural requirement be followed by the prosecution in such a case are to be strictly followed. Any lapse on the count would dent the prosecution's case and would give advantage to the accused. So the procedural has to be very strictly and very meticulously followed. Here, Lordship, I will just sum up with your Lordship. Here, Lordship may kindly see that 8 numbers of prosecution witness has been examined, including the IO. And Lordship may also kindly see that from the statement of the informant and the statement from the IO, Lordship, the seizure has been seizure of the contraband has not been very clearly proved. And here, Lordship, the most important part, seizure was done on 6/10/2018, Lordship. Sample was sent on 11/12/2018, and report was, Lordship, on the 31/1/2019. So this shows a very huge delay in sampling and proving the same. So, Lordship, I will submit before Lordship that prosecution in this case has failed in fact to prove the mandatory provisions of the NDPS Act, and therefore I am entitled for an acquittal, Lordship. Any point on law that the prosecution may come up that I may be allowed to revert back, Lordship? I am concluding my part, Lordship. I have already mailed all the judgments to your Lordships, except the one which is by our own High Court, that I will mail it to your Lordship. In due
I'll
course.
find it. I'll find it also.
Lordship, I'm highly obliged, Lordship.
9/9/2024, na date of decision. Okay.
Lordship. So my part I have concluded, Lordship. After hearing the prosecution, I may be allowed to revert back if any point of law is required to be addressed, Lordship.
I'll start my submission before the lordship that the seizure of the contraband substance lordship, which is seized lordship on 6/10/2018. And the same day it is lordship 10 for the custody lordship on the same date, on same day lordship.
6/10.
6/10/2018, yes, lordship. The day it was seized. And it was sent to the custody lordship on the same date lordship in the evening. And lordship, here lordship, in the PW7 lordship, he also in his statement that he exhibited the FSR report lordship, that is which we can see in the page 22 lordship.
It's 22.
Yes, lordship. Lordship, here it is FSR report that reflect that on 11/12/2018, the sample of contraband substance received for examination. And it is also observed from the exhibit 13 that the sample which is received for the examination was in seal parcel and seal and signature of the PW8 are intact. PW8 lordship, PW8 is the lordship, is the IO or OC lordship, he is the lordship IO of the lordship, this seat of the contraband substance lordship. And lordship, it is also reflected there were 8 still in the parcel containing case exhibit for the examination which are intake and telling with the specimen seal on the forwarding letter. From the above evidence, it is observed that the PW8 has collected the sample and when the FSR received the sample, seal was intact. So there's nothing to disbelieve above material evidence and the FSR.
Yeah, this you're reading from page?
Lordship, it's the page 22 lordship.
Yeah, I'm on 22 only.
Yes, lordship. Because lordship 22 lordship, it is the seal pack lordship. The seal parcel which is lordship marked as lordship sample, it is duly signed by the SP Western and the IO of the case having a seal with the intake and tailing with the specimen seal on the forwarding letter inside it. It's a green color dry leaf forwarding top stiff pack in small box suspected to be ganja, marked the laboratory number 1, which is lordship in the page 22 of FSR report lordship.
Okay.
Lordship, date of the seizure 6/10 lordship, and it is lordship the same day lordship. It is forwarded to the Malkhana lordship, and again from there lordship, it is forwarded for the FSR test lordship on the 11/12/2018. But that is still pack lordship. There is nothing to disbelieve on it lordship. And lordship, here the chain of the custody lordship, it which it is recovered and destroyed lordship, that is under the lordship, specific provision lordship. And lordship, here lordship, my lordship, appellant counsel lordship, he submitted that for 52A NDPS is not lordship, thoroughly lordship, implicated lordship. But here lordship, I am submitting one judgment lordship regarding the procedural lordship, which Mehboob Shah versus State of Madhya Pradesh lordship.
Supreme Court.
Yes, lordship. Para 15 lordship, I am relying.
Yes.
Lordship, it is undisputed that the sample were drawn by the PW9 hence at the time of seizure and not in the presence of a magistrate. However, the appellant has failed to demonstrate that such non-compliance has caused him any serious prejudice, lordship. If no serious, nothing serious prejudice was caused, lordship, on the lordship, appellant lordship, on the accused lordship, then it would not be lordship suffice lordship that this provision is not fully complied. It is pertinent to note that the NDPS Act as it then stood did not prohibit drawing of samples at the spot of seizure. As noticed above, the requirement under section 52(8) is procedural in nature. The documents like Panchnama, seizure memo, arrest memo, etc., prepared by the investigating officer on the spot or during the course of investigation constitute primary evidence, lordship. With regard to search and seizure of the contraband, which cannot be overlooked merely because of some lapse or non-compliance is found in section 52 of the Act. So that we can say in the Kasif Supra also, lordship.
All right.
Yeah, lordship, I am Kasif Supra judgment, lordship. The narcotic bureau in which bureau versus the Kasif lordship. Here I am relying on para 39 lordship. The upshot of the lordship here, the one lordship, the provision of NDPS Act are required to be interpreted keeping in mind the scheme, object, and purpose of the Act, as also the impact on the society as a whole. It has to be interpreted literally and not liberally, which may ultimately frustrate the object, purpose, and preamble of the Act. To lordship, while considering the application for bail, the court must bear in the mind the provision of section 37 of the NDPS, which are mandatory in nature. Recording of findings as mandated in the section 37 is when a non is known for granting bail to the accused involved in the offence under the NDPS Act. The purpose of intention of the section 52A laying down the procedure of disposal of seized narcotic drugs and phytotic substance was to ensure the early disposal of the seized contraband drugs and substances. It was inserted in the 1989 as one of the measures to implement and to give effect to the International Convention on Narcotics and Substance Lordship. And lordship, for lordship, the subsection 2 of the section 52 laid down the procedure as contemplated in section 1, thereof, and any lapse or delayed compliance thereof would be merely a procedural irregularity, which would neither entitle the accused to be released on bail or nor would be set the trial on that ground alone. Any procedural irregularity or illegality found to have been committed in conducting the search and seizure during the course of investigation and thereafter would by itself not make the entire evidence collected during the course of investigation inadmissible, lordship. The court would have to consider all the circumstances and find out whether any serious prejudice has been caused to the accused. Lordship 6, lordship, any lapse or delay in the compliance of section 52A by itself would neither be set the trial nor would entitle the accused to be released on bail. The court will have to consider other circumstances and other primary evidence collected during the course of investigation as only the statutory presumption permissible under section 54 of the Independence Act. Meaning thereby lordship, the primary lordship which is, during the investigation which is collected, this is primary evidence lordship. Here lordship, this procedure mere because of procedural lapses lordship, it that not amount to lordship that the accused is not has not then the conduct the lordship this severe offense lordship. So lordship, we cannot lordship distinguish that the mere the non-compliance 52 is lordship factor lordship that the accused is committed the offense of the seize the contravention substance lordship. Because lordship here the seize lordship it upon the accused lordship when the accused was lordship in his car lordship the seize lordship from his it's not entirely from his body but the vehicle yes lordship which he was possessor he's in his possession lordship. Moreover, lordship, in the regarding vehicle part lordship, the seizure witness is also there lordship. We can see the lordship, the PW lordship, 3 lordship. In the page 46 lordship, may I lordship? I have come to the court as witness in the present case. I have witnessed as the Jimma witness lordship of the owner of the vehicle was Bolada Panika. The vehicle was also this is much the vehicle sent over to Bolada Panika of the police. Here look the vehicle was also which we that accused are driving lordship. He is not his vehicle lordship. He is the hired lordship and the main owner is lordship Bolada Panika. That means lordship the chain lordship. The chain lordship established that lordship the substance lordship which is seized from the vehicle lordship is the vehicle used by the accused which the actual owner was Bola Das Panika. His statement also been recorded. And here lordship the recording of the deposition of the lordship the Jimba witness is also there lordship. That is PW3 and PW4 lordship. And look at the chain is complete lordship. There is nothing in this commentary lordship. Only the procedural lapses is there. And that is lordship in the Mehboob Salih lordship. It is already stated that the mere procedural lapses lordship. It won't be lordship any ground for lordship that it is irregularity lordship and it cannot be ground for the acquittal. I just wanted to show before the lordship, the chain of the lordship, this all the lordship possession lordship, all the lordship, which is the lordship from the staging to the lordship, the laboratory to the forensic lordship, the outcome of the laboratory lordship, the what is result lordship, and lordship whether this P for 52 mere in compliance of the 52 is a ground for the acquittal lordship. It's not a it's just a procedural lapses. Because primarily this which evidence is already collected lordship from the investigation to the lordship forensic expert lordship which they have already before the court lordship that is established that this is a the forensic substance is cannabis lordship and this is in the commercial quantity. And Lordship, moreover, the accused tried to run away, Lordship. And Lordship, most interesting part is also there, Lordship, in the page 80, Lordship, in the judgment, Lordship, which I have just gone through, Lordship, with paragraph 49, Lordship. May I kindly, Lordship.
Yes.
I have heard the learned concept of the convict, Mr. K, this is who has submitted the another date may pick for hearing sentence present. It is observed the convict also wanted another of similar nature, Lordship. That is, he is a habitual offender. For the transporting commercial, that is two commercial quantity of contraband substance pending before this court.
Okay.
Lordship, my simply prayer is that, Lordship, this is minimum sentence being granted, Lordship. This is 10 years.
Yeah.
So it is not.
Commercial quantity is minimum 10 years.
Yes, Lordship, minimum 10 years, Lordship. Lordship, the similar case, Lordship, this Vikas Oro, Lordship, this is, it was already passed here, Lordship. They dismissed, Lordship. In the similar ground, they have approached before the court in appeal, Lordship. Here, Bharat Ambale, Lordship, the court has taken into consideration the Bharat Ambale.
High Court decision. Huh?
Almost similar, Lordship, the non-compliance of 52, Lordship.
Okay, this much.
Yes, Lordship, I've already, Lordship, gone through all the, Lordship, the recording statement
Yes.
has already
Yes,
gone through, Lordship.
Current counsel has taken the court.
Yes, Lordship.
Would you submit any brief reply, Mr. Parasari?
Yes, Lordship. First of all.
Then we can close the hearing today itself.
It will take 2 minutes time, Lordship. First of all, Lordship, they have said regarding the seizure of the contraband and it's sending of the contraband to the Malkhana on the same day. That is the day on which I was arrested, that is on 6/10/2018. Now, Lordship, in the entire proceeding, in the entire trial, the prosecution has never exhibited the Malkhana register. That Lordship may kindly take a note of it. And their own document shows, Lordship, as I have said, Lordship, this contraband was seized on 6/10/2018. Sample was sent on 11/12/2018, and the report of the FSL is on 31/1/2019. Second, now they are saying that procedural lapses, the accused is not prejudiced. Lordship may kindly see that the accused is still today inside. He is not on bail. He is behind a bar. And the procedural lapses that has occurred in this case, the procedural lapses has definitely made him a prejudiced, Lordship. Second, Lordship may kindly see that none of their witness, there is a civil witness, Lordship, civil person. All the witnesses are police personnel. Then including the civil witnesses. Lordship may also kindly have a look, Lordship. They are now saying that Bhola Das was the owner of this particular vehicle. Bhola Das was never arrested. If Bhola Das was the owner of this vehicle and he has been given Jimma even before the court, he was never arrested, Lordship. And this vehicle was a private vehicle, Lordship knows if the vehicle is a private vehicle, then the concerned IO has to send a report to his superior within 72 hours. That has also not been done here. No report is there. Lordship will not find this report entirely, so Lordship takes into consideration. These are lapses, and if these lapses are not prejudicing me, then I have got nothing to say, Lordship. Then Lordship may kindly see one more case that has been referred, Bikash Boro. Absolutely not. Bikash Boro is not at all a similar case. It's a different case altogether. In Bikash Boro, it was seized in a different manner. In Bikasboro, there were defense evidence was given. In Bikasboro was carrying the contraband in his own vehicle. And then Lordship may kindly see that they are trying to say that the accused ran away. It is a prosecution version. There is no medical report that there was bruises, he suffered any bruises or something, and that he ran away. So Lordship may kindly look into here. I would always reiterate one thing, that here there is a blatant disregard of the NDPS Act altogether. And when there is a blatant disregard of the NDPS Act, only because there is a seizure of a contraband, LS seizure of a contraband, 37 regards will not come, Lordship. For the 37 regards to come into effect, first of all, the prosecution has to prove one thing, that NDPS Act has been, the procedural aspect of the NDPS Act has been totally and completely followed by them. And there is one judgment, Lordship, I will mail this judgment to your Lordship. That is Mohammed Khalid versus State of Telangana. I have already given the judgment, the Lordship may kindly see. It is not where Honorable Supreme Court is referring. Admittedly, no proceeding under Section 52A of the NDPS Act were undertaken by the investigating officer, PW5, for preparing an inventory and obtaining the samples in presence of the jurisdictional magistrate. In this view of the matter, the FSL report is nothing but a waste of paper and cannot be read in evidence. That is there in Mohammed Khalid. I will mail this judgment also to your Lordship. So considering all these aspects, Lordship, I will pray that this is a case where Lordship may kindly acquit the accused, Lordship. That's all, Lordship.
Yes, right. Heard Mr. Bhattacharya, Learned Counsel, appearing for online full stop, and L. Hage, learned additional PP for the state. Full stop. Arguments conclude, judgment reserved. Okay.
I'm declared.
Nobody, no problems.